Someone make it make sense.
Probably a couple.
Hello, everybody. Welcome on in. I'm sending Twiz his special text. That Twiz, so special. Shout out to Mittens being the first in the chat tonight. You get the prize, 1,000,000 scroll points. Don't spend them all at once. Also, shout out to Flash. How's it going, my friend? Did you have any tasty food today? For anyone who doesn't know, Flash is a big foodie. Also, Mittens, have you seen the Kitten Mittens episode from Always Sunny in Philadelphia with the kitten Mittens? I sent that to Twiz last night because he hadn't seen it. And anyway, I wonder if that's actually how you got your username, or if it's just because kittens and mittens would be cute or whatever. No Dog Left Behind. I think you've been here before. Welcome back if you have. Welcome if you haven't. But I love that username, which is why I feel like I think maybe you've been here before, but it was a while ago. But welcome on in. You actually haven't. Yeah. If you just like do a little Google search for, or a YouTube search for the Kitten Mittens Always Sunny, it's like short, like a minute. It's so fucking funny. You definitely should watch it. It's definitely like, it's like they made it with you in mind. But love the No Dogs Left Behind username as well. And shout out to all of our new Squirrel friends. Welcome to the Squirrel Crew, where we have the squirreliest Squirrel Crew of all time, basically. Actually, I think that's pretty verifiable as well. So we've got a lot to cover here with Bryan Kohberger. And also, for anyone who was here last night, you may have heard that I was going to be going to federal court today, which I did do. And I've got so much to tell you guys about that as well. But I'll probably wait until we get going on some of these docs, and then we'll talk about that. You guys are going to love to hear what I have to say about this. It was a day I will never forget. That is for sure. Absolutely amazing, and was a big day. No Dog Left Behind says that he or she has been here before and loved it. Awesome. I thought so. And yes, there was a hearing in Kohberger. And in fact, we're going to watch the hearing as well. It's a short hearing, but I have some interesting things to say about that as well. So first, we're going to start out though with this was when was this filed? When was this filed? This was from the 14th. So this is from the media, right? This is why we had this hearing. So you've got all these different people here, right? The interested parties. So this is the memorandum in support of the motion to be heard as interested parties. And we're not going to read all of it, but we are going to read some of the things, the more salient arguments that were made that I found interesting. And I will say I was surprised with what ended up happening at the hearing, which we will get to. Some of you guys may already know. And No Dog Left Behind, thank you so much for the super sticker. I appreciate that. Also, we do have memberships if you, for those of you guys who haven't been here in a while, or if you're new, because the memberships are relatively new. So for anyone who does want to become a member, Nightbot will put the link in the chat as well for that. And if anyone hasn't joined the Discord, also, Nightbot, would you do me a favor? Yes. Cute. Thank you, Nightbot. Love you. And Twiz sent me a text saying KKKKKKKK. So I think that means he is on his way over here. Oh, Twiz. We love you, Nightbot. We love you, Nightbot. So, and for anyone who wants to use these commands, let's also just put that in the chat as well. Just cover all of our bases there with that. So there's the commands for anyone who wants to use them. Okay. All right. So let's take a look here. So as this court has acknowledged, this case has been marked by secrecy. Indeed, more than half of the nearly 500 orders in this case. And actually, let me back up. The reason that they're saying this part, right, is because there was that hearing from like, a couple months ago, or actually, I guess it was in a hearing where he was like, we're not going to just put everything under seal, right? He was like, we're going to be more deliberate about it, And after that happened, there were many things that we got to see more filings, right? But then as it progressed, things were, as y'all know, mostly a lot of things have been under seal since then, as we were approaching what would have been trial. However, I would imagine that there was good cause for that, because he made it clear that they would have to show good cause. And whenever they become unsealed, we might be able to decipher by reading them what that good cause was for having them being sealed. Okay, so anyway, so that's why it says he's acknowledged it. Indeed, more than half of the nearly 500 orders entered in this case, approximately 246, have been orders to seal. From what the media coalition can discern, the primary justification for most motions to seal and orders to seal has been the need to preserve Mr. Kohberger's right to a fair trial. But what? Oh, but Mr. Kohberger's change of plea and the terms of his plea agreement have rendered that justification moot. In the absence of this justification, the continued infringement on the media coalition's and public's First Amendment rights is impermissible. Okay, so now we're going to get to the legal standard here. So we know a lot of this. Again, we're going to look at the more salient points here. Rule 32 allows information to be sealed from the public only, quote, in very narrow circumstances, end quote. When entering, and this is important, when entering an order redacting or sealing records in a case file, a court must fashion the least restrictive exception from disclosure and provide the reason for the redaction or sealing. We've heard about this with a lot of different things, right? But the least restrictive. So if you don't need to seal the whole document, right? If it's just one particular portion, just redact that one particular portion. I will say, in this particular case with Idaho v. Kohberger, there have been documents that are redacted, but I would say that in the grand scheme of things, when you think about how many filings there have been, and you look at the proportionality of it, it's surprisingly few that have been like unsealed but redacted when you compare that to how many are just completely sealed, right? So interesting thing to note there. Moreover, this court at any time may reconsider, alter, or amend any order issued under Rule 32. Okay. Argument. The court should unseal the judicial records in this matter as soon as possible. So this is not talking about speaking to the media. This is talking about unsealing the docs. That's what this is saying. Now that Mr. Kohberger will never face a jury trial and his prosecution, and thus his investigation has included, there's no reason for this case to remain cloaked in secrecy. There no longer appears to be any proper reason for the court to maintain the categorical sealing of the records in this case. Now they're going to give 3 reasons. First, and most importantly, the court should unseal all records in this matter because the primary justification for sealing no longer exists. So they're saying because he's pled, his right to a fair trial is moot, et cetera, et cetera. He waived his right to an appeal, and therefore there is no possible set of circumstances under which Mr. Kohberger will ever face a jury to determine his guilt or whether the death penalty should be imposed. I will say, just to note this for the record, many of you guys have heard us talk about this before, but the sentence has not been handed down yet. And as we've discussed, after a guilty plea has been entered, but before the sentence has been handed down, there are narrow circumstances where the plea can be withdrawn. Okay. So that is still the case until what is it, the 23rd or whatever. But anyway, like in other words, if one of those reasons existed and he did withdraw his plea, then he could proceed to a jury trial. Just saying, up until that sentence is rendered. But anyway, they're saying that there's no circumstance that it will ever happen, and that's not necessarily accurate at this juncture. I mean, even after the sentencing, it's still not impossible. Now, as y'all know, because we've talked about it, the standard goes from, you have to have a good cause and there's a narrow set of circumstances. It goes from that to manifest injustice, right? But that doesn't mean it's impossible. It's not impossible. It's possible. It's just really not likely. Anyways, okay. Thus, there's no need to continue sealing records to preserve his right, quote, right to a fair trial, end quote. Now they're providing some case law. Because the primary reason for sealing the records in this case is moot, the infringement on the public's right to view judicial records can no longer be justified, nor does continued sealing comply with Rule 32. Now they're noting, public trial, As this court has recognized, this case has garnered intense national and even international attention. It is deeply important to the people of the state and remains so despite Mr. Kohberger's plea. However, Because Mr. Kohberger will never face a trial, can't say never, honestly, not never, the public will also never have the opportunity to fully discover or understand the evidence that would have been presented against Mr. Kohberger or the steps that the prosecution and law enforcement took that eventually led to Mr. Kohberger's guilty plea. I find it interesting that that's what they're saying. Let me read this part again. So they're noting the things that would never be known to, that will never be known to the public, because if there's not a trial, which seems like there won't be, right? That the public won't understand all the evidence that would have been presented against him or all the steps that prosecution and law enforcement took. What's interesting is what they're not noting is what also would have come out at trial, which is all of the things they didn't do, all of the holes in the case, all of the problems in the case, right? This is very one-sided, if you ask me. If the record remains, in other words, what do I mean by that? What I mean by that is they're stating this as if everything that would have come out at trial would only have been in the prosecution's favor. It would have only shown evidence against Mr. Kohberger, and it would have shown all the steps that prosecution and law enforcement took. So anyways, if the records remain sealed, especially to the current extent, the public may never truly accept Mr. Kohberger's guilty plea as the ultimate conclusion of his horrific case. But unsealing the record here will not only preserve the public's First Amendment rights, but will also promote confidence in the judicial system as a whole. I mean, that's true, right? That last bit, but I still don't really like the one-sided lens. They could be making this argument, and they could make this argument in a less biased manner, if you ask me. Second, the plain language of Rule 32 now supports unsealing the records in this case. And backing up one more time. When I say less biased, I don't mean they have to be like saying, they don't have to be weighing in on his guilt or innocence or whatever. I just mean less biased in the sense that no investigation is perfect. We know this. So there's that. However, in terms of the investigation and also in terms of the strength of the prosecution's case, this one was quite lacking. And you guys have heard me talk about it and others. So you can, part of the unsealing of the documents, right? The reason I believe they're important is it has nothing to do, again, with, are these documents going to prove guilt or no, but they're going to show the strengths and weaknesses of the case, right? So looking at it from that perspective. And so again, they could be making the same argument, but they could be giving two reasons why this argument is a solid argument and not just one. And two is better than one, right, guys? Welcome on in, Gretchen. Happy to see you, my friend. I did not go to the Diddy trial. The Diddy trial is over, but I was in federal court today. Okay. Second, the plain language of Rule 32 now supports unsealing the sealed records in this case. When the justification for sealing court records is to preserve the accused's right to a fair trial, Rule 32 specifically contemplates that the record only be sealed temporarily. Now, I will say there's other reasons. There were plenty of documents that were sealed not only to preserve Bryan Kohberger's right to a fair trial, but sometimes it was to protect like victims, or like witness name. Like there were other people involved in these documents, right? That they were protecting their privacy and what have you. It wasn't just for that reason. So far, this memorandum has only cited as a basis to have a document sealed as the defendant's right to a fair trial. Now, I guess I kind of understand why they're doing that. Why? Because they're saying his right to a fair trial is now moot, which would mean if that was the only reason things were sealed, then you have no reason to keep things sealed. But they're leaving out the part where there were things that were sealed for other reasons, and those reasons and those grounds for documents being sealed are still here. Like they're still applicable, they're still present, and those haven't changed. But if they were to address that, then I suppose they would be conceding that they can't just unseal everything, and they want them to unseal everything. I mean, I want them to unseal everything too. I'm just assessing it from the legal perspective. Okay. Rule 32 specifically contemplates that the record only be sealed temporarily. And then they have ICAR here. This temporal limitation comports with the inevitable fact that an accused's interest in the right to a fair trial only exists temporarily. Again, this is all only assessing this so far. This argument is still only going off of, the defendant's right to a fair trial. Third, even if another justification may exist for continuing to protect some of the work. Okay, finally, now they're addressing the other reasons, right? Which there are. They're saying may exist. Well, there are reasons for that. But what I would say, if I were the media coalition and I was writing this memorandum, what I would say next is like, what I said before, which is, can't we just redact it? Can't we just redact it? And maybe that's what they'll say. Let's keep reading. It is unlikely that the complete sealing of a record still complies with Rule 32. The Media Coalition understands there may be sufficient justifications for sealing records other than protecting the right to a fair trial. Okay, good. I'm glad they're acknowledging it. However, it appears that the only other exception that has been referenced for sealing the records in this case, and that appears to continue to be potentially applicable, is when the records contain highly intimate facts or statements, the publication of which would be highly objectionable to a reasonable person. To the extent that any such highly intimate facts or statements relate to Mr. Kohberger, now that he's pleaded guilty, they're saying that's pointless. To the extent that those facts relate to a third party, only the court and possibly the parties are in a position to determine whether sealing under the rules remains appropriate. And again, the least restrictive, they must fashion the least restrictive exception, right. Here, even if protecting some information from the public is justified under this exception, it is extremely unlikely that it would be necessary to completely seal any record other than rely on redactions to protect the identity or personal information of the individual. And I completely agree with that. That is a good point, and that is what I was saying. Right, the court will not authorize the sealing of entire documents if only portions thereof contain information that should probably be sealed. Again, and remember, the least restrictive measure. So there you go. Flash is saying that I'm the most awesome streamer on YouTube. Thank you, Flash. In the last 76 years, he was worried about the FOIA and names of people. Wait, who's he? Who's he, Gretchen? Also, if that's you, you're very pretty. Okay. So, okay, also noteworthy, right? It is the burden of the movant, not the court, to demonstrate that an entire document should be sealed as opposed to redacted. Okay, that's important, right? So in other words, whenever they had these documents that they wanted to be sealed or whatever, it's not up to the court to demonstrate how much, if any, should be sealed. The burden is on the movant, right? This preference and least restrictive means test is apparent in the court's most recent order regarding alternate suspects. So they're saying, Judge, you've already done this. Look, you didn't find it necessary to seal the whole order. You just redacted certain parts about the identities, Yeah. So, it's always a great thing to do when you can, flatter the court, but also say, look, you agree with yourself, right? You've already done this and we agree with you. We're all in agreement. Okay. Let's see here. I mean, and this is true. Additionally, many of the court's orders do not expressly clarify what specific exemption justify the sealing of record. That's true, right? Like, again, there were no there was no bases in the record for this is why it's being sealed in many of the orders. That's very true. They sometimes, I feel like they just kind of got lazy with it, right? Where it's just this is sealed pursuant to the rule. Okay. Well, the rule is very broad and has a bunch of different grounds by which things can be sealed. Anyways, so by citing just the general rule, it's a cop out, in my opinion. Given the inherent challenges mentioned, it is generally, quote, the party seeking to keep the record sealed that bears the burden of justifying the secrecy, even where, as here, the district court had previously determined that those documents should be sealed. Citing some case law. And here we have a footnote. The Media Coalition maintains its position that the most appropriate path forward, given there is no longer a need to protect Mr. Kohberger's right to fair trial, is to unseal all the records in this matter. If the state or defense believes that there is sufficient justification to reseal a record for some other reason, either party can renew its request to seal specific records that would ensure. Well, that's dumb. I don't think that's a good argument because once it's been unsealed, if you reseal it, it's too late. Cat's out of the bag, all that, right? It would be, and I think the reason they're saying that is because they want everything done quickly. In other words, if they were to say just as a blanket thing of okay, everything's unsealed, then everything would get unsealed, right? And because it would take time to go through each individual document and assess, should it stay sealed? Should it just be redacted? And they want everything quickly. So they're saying, don't take the time to go one by one and then release it correctly the first time. Instead, just let everything out. And then if you're oops, we fucked up, then just try to fix it. But I don't see the point in making argument like this to the court when I mean, how could they sit there with a straight face and try to say that the court would be like, yeah, that's a great idea? No. You know what I mean? Like, make argument that the court will actually consider. Okay, anyways. And then we have another footnote. To the extent that these orders and ones like them do not comply with the requirements of the rule, this is further reason that the court should unseal the records in this case. Okay, let's see what y'all are saying in the chat. Welcome, Carla. Happy to see you guys. Idaho's going to be buying up. Right, I know. That's so funny. Since when does the state choose to be so secretive? You think they would be bragging about nailing his... Oh, I think you're trying to say nailing his ass to the wall if they could. Well, yeah. And actually, I mean, again, that's the only reason that they would agree to a plea deal is because there's problems with their case, as we've talked about extensively. Yeah, there's a new book out about Kohberger by, what's his face, James Peterson. I don't know much about it. I haven't read it. I don't really care. But there is a book out. Okay. So again, the burden is the respondents to demonstrate the absence of a need for public access. Yeah, this is important. Okay, let me point this out. What they're saying is this. Just like how, remember, just think about like the burden when it comes to guilt or innocent, or guilt, or, you know, like the defendant is presumed innocent, right? In any case, right? They're presumed innocent. The burden is on the state to prove that they're not innocent, right? They're cloaked in innocence unless and until the state can prove otherwise, or the federal government can. Similar thing here. What they're saying is the law presumes that the public is entitled to access the contents of judicial proceedings. The law presumes that we should be able to see it. So again, similar type of thing where it's like you have to, the respondent has to demonstrate that it shouldn't be public because the law presumes it should be. Thus, if either the state or Mr. Kohberger believes that any records in this case should remain sealed, it is their burden to show that the judicial record continues to fit with one of the very narrow circumstances justifying sealing. Unless either party is able to do so, the court should unseal all the records in this matter. Conclusion. Simply put, the need to protect Mr. Kohberger's right to fair trial is no longer a legitimate purpose for sealing judicial records in this matter. For that reason, and the reason stated in this memorandum, the Media Coalition respectfully requests that this court grant its motion and unseal all the records in this case. Stole arrives? My brain wanted to read that as stovepipe initially, but that's not what that says. Okay, next we have what do we have? This is the state's response. State's response. Also, Carla, how is your orchid doing? And did you repot her? Flash says, LOL, Chelsea's like that book that's just pure speculation. Yeah, exactly. That 100%. Yep, accurate. Why was there a gag order on a homicide of students over 18 anyway? Well, the primary reason, of course, right, is to protect the defendant's right to a fair trial. So it's less. So it doesn't. It's not about the, like, in other words, with any in any case, regardless of who the victims are or how old they are or how many there are, you have to protect the defendant's right to a fair trial, and a lot of that has to do with things being out in the media, right, and then poisoning potentially the jury pool. I think maybe what this question is asking is because are you following? For example, like no dog left behind to you. Are you following like Stepson Stearns and whatnot? Or like, are you referencing this in comparison to cases where the victim is a minor or a child? And that might be where you're coming from. And I can understand how if you've been heavily following those cases, a lot of the discussion potentially about things being sealed would be because of the age of the victim. And I could see that why that would be on your mind. But protecting the victim's privacy and whatnot is secondary. It is a reason, right? But the primary reason is the defendant's right to a fair trial. And I will say to the end that it is in reference to something like Stepson Stearns or anything like that. Anything that would be, how shall we say, things that no one should ever have to hear about, see about, or know about when it comes to the child would also, without any question, meet that criteria. It would also be prejudicial towards the defendant, right? So in other words, anything that would be anything dealing with a minor like that in a case like where you've got like a Stepson Stearns case, it is also going to be prejudicial against the defendant as well, in addition to being stuff that no one should ever have to see about a minor. So yeah. Yeah, I'm sure that some of those docs are sealed in Stearns. Yeah. I mean, and then take, like, for those of you guys who were here when we were doing the Zachary Hughes case, right? You know, there's that Bradley Post case, right? And I haven't checked in on that, but that's another one. You know, he's awaiting trial on like a bazillion counts having to do with CP and all that, right? That entire, like, I think everything in that case is sealed. Pretty much. Like, it's that bad that they're like, no one can ever see. Like, it's that bad. And I'm fine with that. Like, I just, you know, and again, everything in that case would be harmful to the victim, which in that case, the victim is still alive. The children are still alive that were involved. But yeah, that would not be the right thing for them. And they were minors, but also, again, it would be prejudicial to the defendant. Oh, that's awesome, Carla. She still has her blooms. Okay, great. I love it. Well done. Good job being a good orchid mom. Oh, you haven't followed any other cases. Oh, okay. Interesting. Yeah, it just seems like your question is like, you have knowledge that there are in certain cases, right? There's particularly sensitive information if dealing with children or minors, and that is true. But yeah, but for anyone, you know, yeah, it's good to know. Like the primary reason for any decision that is made at all in any criminal case, the first and foremost consideration is the defendant's right to a fair trial. That is first and foremost. Remember, guys, the state or the federal government do not have constitutional rights. They do not have constitutional rights. When we look at the Constitution, the public has rights when it comes to trial, right? Like, it's a public trial, but the rights that matter first and foremost, that trump every other right, is the defendant's rights to a fair trial. So more so than the public's rights to access, because it's public record and public hearing and public court, right? Like, we have those rights, but those rights are trumped by the defendant's right to a fair trial. I couldn't agree with you more, Gretchen. The one person that wasn't included in the gag order is the one that should have been Steve. Yeah, 100%. 100%. Just a flower. It's not just a flower. So much more. Okay, so now we're going to get to the state's response. Comes now, the state of Idaho. The state will not oppose the motion. So they're like, we have no problem with this. So they're like, you can unseal it. Remember, okay, let me just clarify. The motion to vacate the non-dissemination order, as we know, the non-dissemination order dealt specifically with the parties, in this case, talking to the media. So what's interesting is, like, they're referencing this motion to vacate the non-dissemination order. However, honestly, everything that we just read in that memorandum had nothing to do with, we want to be able to talk to the media. It had nothing to do with that. They talked only about unsealing documents, which is separate from the non-dissemination order. So this is a little bit, I wonder if they'll elaborate, right? In other words, when they say they don't oppose it, did they read it? Are they saying they don't oppose to all the docs being unsealed? Or are they just assuming that their motion was based, the media's motion was based on talking to the media? And anyways, let's just keep reading. The defendant pleaded guilty. Yeah, we know. At the charge of change of plea hearing, the court asked for parties for their position on whether the NDA should be maintained. The state requested, and the court granted the request for the NDA to remain in effect through sentencing. Upon further reflection, the state withdraws its request. Now that the defendant, that's interesting. Why? Tell me why. That is interesting. Like, because when we heard that in the hearing, it was the state that made that request. The judge was like, I'm going to go ahead and, is there any reason why I shouldn't vacate this? He was like, going to do it. And then it was Santa that spoke up and was like, well, we want to keep it until sentencing or whatever, right? And then the defense was like, we don't have any problem with that. This is interesting to me, guys. What is going on? I mean, this is actually, the state requested, that's true. And the court granted for it to remain in effect. They've had a change of heart. Why? Upon further reflection. What are you reflecting upon? I want to know. The state withdraws its request. Did you just make a mistake? Were you that careless? Did you not really actually consider it? Like, that's not good either. It's like, either you weren't really thinking and you didn't really have good cause to ask for it to be maintained, which that's a problem, or there's some crazy reason why now you're changing your mind. There's got to be one of the two. Now that the defendant has pleaded guilty, well, he had done that before that came up in the hearing. The defendant pleaded guilty to everything in the indictment. The last thing that came up in that hearing after he pled guilty to everything was Judge Hippler bringing up the NDA. So this is a false, This is a false argument. This is not what happened. They can't say that they changed their mind because he's pled guilty to all 5 counts. That had already happened. I swear to God. I swear to God, Santa. It's gaslighting, man. What's the real reason? Oh, Mary had bingo night again. Love it. 7 shots in. So for anyone who doesn't know, Mary goes to bingo night, and apparently many shots are usually involved, and that is the thing. But they make sure they have a safe ride, right, Mary? Bryan didn't enjoy those rights. You mean his right to a fair trial, or like what are you already referring? I mean, this could be referencing many different things. So I love having discussions, as you guys know. So if you want to clarify so we can have a discussion, then feel free. Why would you file a motion just to say no objection? Well, because they initially they initially requested it. Initially in the hearing, in the change of plea hearing, the state was the moving party that requested the NDA stay in place until sentencing. This is dumb. The state is dumb here. Flash lost a $20. What were you betting on? Oh, I see what you're saying, Gretchen. Yeah, so you're referencing what happens in the hearing, which we'll get to. I was very surprised by many things with this. Yeah, there was a lot of surprises. So we're going to get to this. Not today, Santa. I love that. That's great. So yeah, all right. They have a change of heart. Nevertheless, out of respect for the integrity of the judicial process and privacy of the victims and families, the prosecution team does not intend to make any public statements. Okay, the question I was just asking, where I was like, did they actually read it? I think this answers the question, because they finished this out by saying the prosecution does not intend to make any public statements, like statements to the media, until after the sentencing is concluded. So this does answer my question that I was having, which is that Santa seems to think that the motion from the media coalition was dealing with only the NDA, which again is just specific to the parties talking to the media. And again, I'm basing that on the fact that they're saying we don't intend to make any public statements. And they seem to have completely, they didn't read it, because the entire fucking memorandum dealt entirely with unsealing all the documents and didn't reference even once media talking to cameras. It didn't say that. It didn't even talk about that at all. It was only unsealing the entire judicial record. So I don't think Santa or anyone on the prosecution team read it, because they seem to think it's just dealing with talking to the media. So this is just, I don't even know. I don't even know. Hi, Kane. Welcome. Where is Twiz? He said KKKKKKK at 11:39. Twiz, where are you? If Twiz doesn't pop on here soon, Kane, you can have a round 2 if you want to come on and join us for some reading here. You did a great job last time. Everyone, I think, was really appreciative of you, and especially after having just hit your head in your effort to get your blue basket. What is it? Blue basket ice cream? Blue something ice cream. Okay. So now, next up. This will be the first thing of the things regarding all this that we've talked about tonight that really surprised me in terms of the parties. Well, that's not true. I guess you could say I was surprised that, well, I guess there's been a lot of surprises, but one surprise was that the state just completely had that change of heart, right? As we just read. But also, it seems like all along, right, the defense has really wanted things to be public, right? For the vast majority. So I found this surprising that they are opposing this. Kane's trying to order. Well, why are you getting a free pizza? But that sounds like it should probably be a yes, especially if that free pizza has a time limit on it. Like, is it just a one-time thing or a coupon or what have you? All right. And it's redacted. At least it's not sealed. So the defendant's opposition to motion to vacate the non-dissemination order. So I mean, when this posted, I was surprised. I was like, they're opposing it. Okay, interesting. All right. Mr. Kohberger's request is based on 1, the language of the order that had not been previously challenged by the media, 2, the ongoing publicity regarding the case and threats to Mr. Kohberger's safety, and 3, the hold order for all witnesses issued by this court. So I guess what one could say that is new that they're referencing, that could be the reason why they might be taking a different stance than what we've seen previously, is because in the wake of the plea, there's threats to his safety potentially. And so that would be valid. Like if they're saying, oh, this has changed, and so now we're changing our stance on this, that's fair. Bluebell. Okay, I was thinking blue bonnet, blue basket, blue bunny. It's bluebell. Lord. I'll get it one of these days, Kane. Quick question: is cookies and cream ice cream healthy? I want to say yes because I feel like you deserve to have it. So if it being healthy is what is stopping you from eating it, then I'll say it's healthy. See, look at Mary setting a great example. Eating Nutella. Wait, what are Nutella cookies? What even is that? Huh. Hi, James. Welcome on in. Happy to see you. So, okay, the language of the revised amended non-dissemination order issued on June 23rd specifically ran through sentencing. Okay, I'm going to go ahead and push back and say this. While that may be true, it also says that the court can vacate it or amend it at any time. So it's not like just because it said it ran through sentencing, it means you can't change it. It has, like, that's not a hard fixed. It's not the best argument, but we'll see how they address this. In response to significant litigation and an Idaho Supreme Court ruling on this issue, and there's a footnote. On March 24th, the Idaho Supreme Court denied the media's petition for writ of mandamus or writ of prohibition. Well, that was in 2023, though. That was in 2023. Okay. Oh, Lord. The court issued a revised amended non-dissemination order. Okay. The order was, quote, to remain in full force and effect until conclusion of a trial and any sentencing proceedings that may follow unless ordered by its court, end quote. The revised order recognized that his rights extend beyond the question of guilt or innocence and into a fair sentencing proceeding, regardless of whether that proceeding is reached via a jury verdict or plea. So what they're saying, I mean, I don't disagree, right? You've got the media saying, well, his rights to a fair trial are moot now. And they're saying, no, his rights extend, I guess it would be rights to a fair trial, but just be his constitutional rights, extend all the way through sentencing. So this is like, but they haven't, okay, keep reading. I was going to say they haven't provided any case law to back that up, but it looks like that's coming. So I'll keep reading. The motion filed by the media to vacate the revised order asserts that once a guilty plea is entered, that his right to a fair trial under the Sixth Amendment is extinguished. Right, that's what they said. What the media fails to recognize is that Mr. Kohberger retains his rights to a fair sentencing proceeding guaranteed under the 14th Amendment. I want to see the case law and his right to effective assistance of counsel. Well, they're not saying they cited the case, but not what the holding was that is applicable here. That's unfortunate. Maybe it's coming up. Let's just see here. Okay, here it goes. Okay, a defendant's right to effective assistance of counsel extends to all critical stages of the prosecution where substantial rights may be affected. And okay, well, I mean, you know, I try to be objective, right? Because I'm so far, you guys can probably tell, I've got quite a lot of criticism for this because let me go back up here. Well, this would be a really fair point, right? If they say, okay, the media fails to recognize that Mr. Kohberger retains his rights to a fair sentencing proceeding. I want case law. They cited a case, but not the holding. I want case law to back it up that says his rights to a fair sentencing proceeding, right? That it goes all the way through, that, you know, you have to retain those rights, da, da, da. But then they give the second reason, which has to do with effective assistance of counsel. And if only to make it more glaringly obvious, they do provide the holding that applies to that. And it's really kind of sad because, like, that's irrelevant. Like, why are we talking about effective assistance of the counsel? Like, what? No, that's not what's at issue here that I can glean. And why are you providing the holding for this, but not the one that actually matters? I mean, maybe it's because they really don't have anything that's on point to support their argument, in which case they should lose their argument, right? I mean, you have to have case law. In this case, substantial dangers of prejudice to Mr. Kohberger exist up and through sentencing. As this court is well aware, there have been numerous leaks of confidential information to the press, and the avalanche of publicity continues. Well, there's the documentaries, and there's the dumb book. There you go. There you go, Flash, dumb book. Lifting the revised order now, this close to sentencing would only increase the media frenzy and publicity around the case. I mean, and the thing is this. They're not making great arguments here, but what I have said before, and I'll say again, is like, we've only got how many days to go? 18, 19, 20, 21. It's only 6 days until sentencing. So to me, it's like, look, if let's just say hypothetically, if all parties involved make argument and provide case law that is equally supportive as the other party, so that one party doesn't have the upper hand in terms of the case law, whatever, their arguments are equally valid, equally as fleshed out, what have you. If you imagine a situation where all things were being equal with all the parties in terms of what they want with this, in my view, the right call will be, let's just leave it until sentencing is done, because it's only 6 days away. Like, come on, people, but I will say that all things are not equal, because the media coalition wins on this one, in my view, in terms of the strength of their argument. And they've provided a lot of supporting case law. And I think that if you're assessing it objectively, just from the pleadings, right? We haven't watched the hearing yet, where they, I guess, argue a little bit. It's a short hearing. But based on the pleadings, the media, if I were the judge, the media would be winning on this one. However, with the caveat that the media is trying to sneak a deal in, unseal all the docs. No. Vacating the non-dissemination order only applies to speaking with media. So they're almost trying to, they made they had strong argument, and they had all this case law, but they're wanting it to apply to what it doesn't apply to. That would be their fatal flaw, in my view, right? Like, if I was assessing this as a judge, I'd be like, look, you win. You provided all the case law. You had better, like, you won. But let's just remember that what the non-dissemination order is, because that's what you won. You can't just sneak a doodle other things in. And now they're talking about the threats to his safety because of publicity. Further release would only serve to gin up the anger and violent rhetoric already at a fever pitch. I mean, I don't know that it could get, I don't know that it would get worse. I mean, honestly, can it get worse? I don't know. At this point, the press has access to every witness who is not an agent of either party. Both parties had no objection and indeed sought to have the revised. That's from July. I mean, that's true. Both parties had no objection. But again, to be more specific, the state moved to have it stay in place, which is actually a stronger stance. If the state had just had no objection and they both said that, that's neutral. But the state moved to keep it in place when Judge Hippler's inclination was to go ahead and vacate it. Also, this business is not. And look, you can click on it. What happens if we click on it? I will just say, like, this is just not, professional is not the right word. This is not how you want to have anything in a pleading, whether it's a footnote or not in a footnote. This is just not. Every time that we see this, I see this, and also other law tubers, not that I consider myself a law tuber, but anyways, it's like, ugh. Not that there's anything wrong with a hyperlink, but like literally all of these, like, this is just, can't you just like give it a different name? Anyways, what happens if we click on it? Okay, it took us to this. Can you guys see that? Yeah, Idaho student. Oh, I didn't even know this one was just, which one? See, I'm getting them all confused because, like, I thought this was the same one as the other one, but I guess it's a different one because there's the Amazon one. I guess this is a different one. I mean, it's hard to keep them all straight, and I don't watch them anyway, so now I'm just going back to this. Oh, and it reset the Zoom. Oh, okay. Let's see what you guys are saying in the chat. Right? When was the last time someone used the term gin up? The great question is a legal term. I wonder, I wouldn't be surprised if you were to like somehow hypothetically be able to like scour every single court document in any jurisdiction from any period of time. If I had to try to make an educated guess on how many other times gin up has been used, I would make an educated guess of 3 times in the history of all the documents in the US for court filings. And that might be being overly generous. It might be like 1 other time. I mean, it is not a legal term. And I honestly don't even really know what it means. It's such an archaic phrase. Does anyone know what that is supposed to mean? Gin up. It's just weird. Okay, so let's go where we were here. Okay, yeah, the hyperlink. How can I zoom in? Why is it the layout different? Anyway, okay. Still don't know where Twiz is. Is Twiz alive? Twiz supposed to be okay. Now we have some redactions. The court has issued a records hold order. Oh wait, hold on. Sorry, we didn't read this part. Oh, court security. Okay. Okay, so they're back to security. Okay, the court has issued a records hold order. In its response to the media motion, the state now withdraws its request for the non-dissemination order to be continued until sentencing. The state cites further reflection. So I'm glad they're bringing this up because you guys heard me lose my shit over this. And continues that out of respect for the integrity of the judicial process and the privacy of the victims and their families, as they consider their rights to provide victim impact statements at sentencing, the prosecution team, and that's in bold and italics and has a footnote, which we'll get to in a sec, does not intend to make any public statements about this case until after sentencing has concluded. All right, here's the footnote. From the language, who is, quote, promising, unquote, not to speak to the press is vague. Does this mean the attorneys, staff member? Okay, this is a great point because as we know, when it comes to legal documents, right, and proceedings, when they say the prosecution, that technically also includes all of law enforcement that was on the case, anyone who's working for the government, right? If you're not on the defense and you're working for the government, you're part of the prosecution as the way the law defines it. So this is a good point that they didn't really clarify, right? So yeah, does this mean the attorneys, staff members of the prosecutor's office and or all of the 150 law enforcement officers involved in this investigation? On July 2nd, 2025, an entire row in the courtroom gallery was occupied by law enforcement who were watching the proceedings. Will a third of the courtroom now be allocated to law enforcement, free to provide media interviews as they enter and exit the courthouse? I don't think those questions are necessary. I think they could have left it at this first question. The rest that's not necessary. Just, when you include shit like that, it weakens what was initially a strong argument. Anyway, okay. The state's promise rings hollow, given the previous leaks from sources, quote, close to law enforcement, end quote. Well, but if, all right, because they're saying they promised not to talk. Anyways, okay, conclusion. Mr. Kohberger requests the court deny the media request to vacate the revised order ahead of sentencing in order to maintain the integrity of the process and the security and safety of all parties involved, including the families, court staff, and the attorney. The revised order should remain in effect. The revised order is reasonable in scope and does not impinge on the media's ability to investigate and report on this case, and maintaining the revised order will minimize the media frenzy leading up to sentencing. Okay, with that, we're going to get to the hearing, which there were many surprising things in this hearing. I will say, I did see parts of it. I know it's short, so you're going to be like, what the heck? But you guys know I had a crazy big day in federal court, and I literally caught I think only the very tail end of this for the most part. But what I will say is, from what I saw, I can say with a fair amount of confidence that of all the hearings, looking back on Judge Hippler since he got assigned to this case, looking back on everything, to me so far from what I saw, this might be, in my mind, this might be my favorite. Well, favorite's not the right way to put it. It seemed like this was him at his most reasonable, even-handed. I don't know. Well, I'll think of more words as we watch it, but basically this was my favorite, if you could say my favorite of the hearings I've seen him since he was on the case. And again, it's a pretty low bar because I've had a lot of issues with Hippler, but I was pleasantly surprised from what I saw. Even if I was surprised by his actual ruling, I was pleasantly surprised by how he conducted this and, his findings. Anyway, let's just watch it. Court will begin soon. Okay. All right. Here it is.
All right. We are on the record in State v. Kohberger, CR 0124-31665 present today by video is the defendant in custody with counsel, Ms. Taylor, Ms. Barlow, and Ms. Massoth. State is represented by Mr. Thompson, Mr. Hurwitz, and Ms. Jennings. On behalf of the media petitioners, we have Ms. Olson and Mr. Pedersen. Today's hearing is to discuss.
Why were they on Zoom? Probably because the Media Coalition people live in other places. I don't even know that all of them live in Idaho. And there's probably others that are even like not on the screen, but that are like listening. But if you saw from the court filings there, the Media Coalition lists like 50 bazillion people, and they all have the right to be present for this. And there's no way, practically speaking, that they could have done it with everybody in person. Like they don't even have a courtroom big enough anywhere for that. You know what I mean? Anyway, so it's just for practicality purposes, but good question. And honestly, they've done whenever they've done these like hearings with the Media Coalition, I think that the majority of them have utilized Zoom again for practical purposes because, you know, they can't all be there.
Discuss the media's request to terminate the non-dissemination order. The state filed a response indicating it was no longer objecting to that, and the defense did file an objection indicating that they do have a continued objection to lifting the non-dissemination order. I've read the briefs that have been provided by the parties, and I'm going to attempt to shortcut things here a little bit by.
Here's what I will say. Just from hearing that statement right there, and based on what I just said, remember when I was just assessing the, assessing the strength and the effectiveness of from each party, right? The media, the state, and the defense. And like literally what I was saying is like the media wins in my view, just based on the pleading and who has the strongest argument, provides the most case law, and like the law literally points in their favor. Him saying this automatically, I'm like, yeah, I know exactly what he's going to say. He was like, it's clear. It's clear. It's not even, it's yeah, the media wins, I think is what that is.
Asking whether the defense, who is the objecting party, has anything additional to add beyond what it had in its briefing before. I don't know that I need to hear from, frankly, the petitioner. I think the briefing was adequate, so let me just start with Ms. Taylor to see if there's anything else she wants to add.
Your Honor, there is not, but if there's further argument, Ms. Barlow will be making that argument on behalf of the defense.
All right. And to be fair, Ms. Olson, was there anything you felt was important to add that was not contained within your briefing?
Your Honor, we would just briefly say in response to the defendant's brief, we certainly understand the expressed concern about the media coverage of their client. We don't think continuing the non-dissemination order helps that at all. It simply continues to limit the ability of the members of the press to reach out to the people who know the most about the case. It doesn't obligate them to say anything. We also understand that they expressed that there was a due process right related to the sentencing. I read the case that they submitted. I think that there is obviously a due process right at sentencing, but I don't think that case is really it doesn't provide any guidance to the court here, because that was about information provided to the court, and given the very limited scope, and we understand it's very important, but given the very limited scope of what's to be decided at the sentencing, we don't think the arguments that Mr. Kohberger made should outweigh at this stage the First Amendment rights of our clients. Thank you, Your Honor.
Thank you. All right, in light of that response
First
by
Amendment for the win.
Media outlets,
Remember,
or interested outlets.
Remember, the law presumes everything should be public. Remember, the law presumes everything should be public unless and until the moving party shows good cause and can provide that to the court why something should not be.
Ms. Barlow, do you want to add anything?
I would only say, Your Honor, as this court is well aware,
the publicity in this case is so extensive and emotions are already so high.
I don't disagree with what she's saying. I'm not saying that's not true. That's just that argument doesn't have anything to do with this. It's just not a good argument. If I spent about 10 minutes and went back through their filing and then like the medias and the states, and like if I took like 10 minutes to go back through it, I bet I could come up with a better argument in my mind or my opinion of what they could have made just to be successful with their objection. And this is just not it.
That adding fuel to the fire of
This isn't even like a actual legal argument and whatever.
media interviews or a rush to interview people as they leave the courthouse or enter the courthouse would only increase the concerns that the defense has. And even though the plea has a specific sentence attached to it, as this court is well aware, things happen in plea hearings and, sentencing hearings. And to minimize the possibility of that, we request that this order stay in place.
All right, thank you.
I want to pull up this from Flash real quick. Thank you, Flash. I love this. So Flash says, and by the way, I saw a thumbnail for the video of what you're talking about, but I didn't watch it, but I know what you're talking about. There's a woman who just took back her plea today. She pled guilty, getting into an argument with the judge. Then she said she had evidence to prove her innocence. So the judge allowed her to take back her plea. First question I have, had he already sentenced her on whatever, what would the charges be? Like getting into an argument with a judge. Well, okay, that's not an actual, like, what would it be? Contempt of court, right? Like what was her charge, first of all? Second of all, had she already been sentenced on that charge? Because the reason I'm asking is because, again, if she says she's gotten evidence to prove her innocence, that would fall under one of those limited exceptions. But I would, from what I understand, I don't know anything about it, that's why I'm asking for more information. It sounds to me like this would be an exception before sentencing, depending on the strength of the evidence. Now, if it's like, I'm not saying this lady has this, I don't know anything about this lady, but let's just say in a case where there's like definitive exculpatory evidence. And we read about this in the study on the last live stream where people that are exonerated, right? Where these are people that pled guilty and then later on and are on death row and later on definitive exculpatory evidence comes out that shows they couldn't have done it, right? So that would be manifest injustice, which would be the only way once you've been sentenced to withdraw a guilty plea. But again, the standard is a little bit different before sentencing. So let's see if Flash has elaborated. First degree accused. Oh wait, what? Sorry. Okay, I thought you said that her charge had to do with fighting with the judge. Hold on, I just misunderstood this. Okay, I thought you said she took back her plea of getting into an argument with the judge. Okay, now I need to completely reassess this. Okay, let me take another look here. So first degree accused of cutting her boyfriend's head off. Okay, right. So she pled. Okay, I see. So she pled guilty to first degree murder, has not been sentenced, and then so this makes perfect sense. It makes perfect sense. That makes perfect sense. Yeah, she hasn't been sentenced yet. So if she's got evidence that she thinks can prove her innocence, that would be one of those limited reasons how after pleading guilty, but before sentencing, you can, remember, it's like you have to show good cause, and there has to be a really good reason, basically, under limited circumstances. And I think there's like 3 categories, but one of them would be something like this, right? If there is new evidence that can prove her innocence, or not even new, but like, I guess she's deciding to offer that evidence up, and to prove her innocence, yeah, she can take back that plea. Again, after sentencing, though, the standard becomes manifest injustice. Oh, and there's Twiz. Hi, Twiz. What the hell? What have you been twizzing? Were you doing a twerk out? Were you doing a twerk out? She was in court for sentencing. Okay, so you're saying she was in court for sentencing, and at that proceeding, before he handed down the sentence, that's when all this occurred, where she's like, hang on, before you sentence me, I want to withdraw my plea because I have new evidence that shows I'm innocent. Am I understanding? Maybe I should just watch the video. But is that what you're saying happened here? Kane says he can still read. Good job, Kane. Proud of you. Should we watch it? Oh. Is that on one of, where is that? Is that on YouTube or is that like one of the documentaries? I honestly couldn't be bothered with what he's saying, but I am curious about this plea thing that Flash is talking about. I'm not patronizing you, Kane. You did an A+ job last time with your reading. I think you're great. So confirmed, Twiz was not having his twerk out. He was watching Steve Gonsalves' interview, I guess. So let me see if I can find that video that Flash is talking about. Give me just a moment. Actually, I guess I'll play this while I'm finding the video. Let's do that.
All right, as the court has considered the petition, frankly, the court was prepared at the time the plea was entered to lift the non-dissemination order in order to give the parties time to evaluate that and to ensure I wasn't missing anything. When both sides objected, I agreed to continue the non-dissemination order. I also indicated that I would have the potential to look at that again before sentencing, because frankly, I anticipated the motion from somebody, in this case, the Ms. Olson and her clients, was likely to be coming. And at this point, I do not believe the purpose of the non-dissemination order, the primary purpose, which is to ensure that we can seat a impartial jury, is any longer at play. The concerns identified by the defendant, will certainly not to minimize those. They are concerns and they are significant concerns. I do not think, however, the non-dissemination order and the right of the public to information is outweighed or outweighs those rights, I should say. And frankly, I don't think that lifting the non-dissemination order will meaningfully impact those concerns. I mean,
Literally what I was just saying. Remember, guys, when I was criticizing the defense argument here, I was like, yeah, that's a weak ass argument. He's being honestly quite tactful for him. He could have definitely laid in. I mean, it was a really weak argument, and he's being very balanced in how he's like, again, like I was saying, of all the Judge Hippler that we've seen, I was pleasantly surprised. And I in my mind, like, this is like him at his best for what in my view of what we've seen, where it's like, he's not like, anyway, it's just interesting. I don't know what happened. Like, he's got a totally different type of perspective, it seems like, for some reason in this particular hearing. Okay, so here's this video of the lady. Let's see what's going on here and how she's changing her plea, withdrawing her plea rather.
Versus Devin Michaels. May the record reflect that Ms. Michaels is present in custody. Ms. Patrick is here on her behalf. Mr. Giordani and Ms. Griffith are here on behalf of the state. Mr. Dave comes up for sentencing. Are both parties prepared to go forward?
Yes, Your Honor.
Okay, so she's here for sentencing. Again, this was a first-degree murder. I don't know much about. I don't know anything except for that, right? First-degree murder. She's here for sentencing.
All right, state this is a stipulated
And she pled guilty. She pleaded guilty.
sentence. Anything you want to add?
I do just a couple of things, Judge. First, we have 3 victim speakers. I asked if they permitted me to speak last.
Okay.
We obviously went to a settlement conference. We stipulated the sentence. I think that the life tale reflects the gravity and the haunting nature of the facts. As you know, the defendant not only murdered her ex, but then desecrated his body by decapitating him and putting chemicals on his body, causing it to burn. The defendant admitted to the fatal blow. She never admitted to the decapitation portion, but the evidence was overwhelming that it was obviously her who did it. Another haunting fact, and something that
Twiz, are you asking if this is Ann Taylor? No, I don't even know which state this is in, and it doesn't really matter for our purposes. I need to cover that up. We're just going to see what happens with her withdrawing her plea. But also, did you ever answer the question of where that interview was, Twiz?
concerning, which supports the life tale, is that the defendant had a corollary child abuse case pre-existed this. We reviewed, Ms. Griffith and I reviewed the minutes in
That's
that
Ms.
case,
Griffith.
and it appears that 2 days after she murdered and decapitated her ex, she appeared in court
real.
in front of another judge in this courthouse and made representations that she was staying out of trouble and obviously had that on.
Twiz, it's Miss, what did he call her? Miss Harper? I literally just answered. Okay, first of all, I've already answered your question, Twiz. And so have people in the chat. This is not Ann Taylor. This is, I don't even know what state this is in. This is Miss Harper. But and meanwhile, Twiz has not answered the question about where the interview was. Anyways,
The conscience at the
Classic
time, walked
Twiz.
right back out of the courthouse.
There you
and
go.
Ultimately was developed as our suspect and arrested. We take this case very seriously, obviously the family does as well. We believe the sentence reflects the gravity of the crime. So we will submit it. We do have some updates on CTS, which was wrong in the PSI.
Correct. I calculated the credit at 455 days as of today.
Okay, that sounds great.
Because I calculated in regards to, she was on probation when this
There you
offense
go.
occurred. She then got that sentence imposed. She was released on that sentence, so she started accumulating the credit on that day. And I have it at 455 days as of today.
Yes, and we also have restitution requests. We've now received documentation.
Actually, I have received documentation.
Right, we just received it this morning. We showed it to Mr. Patrick. It's supposed to be 5,000 to VOC,
I have
this is going to be really interesting. I wonder when she changes her plea.
1,923 to James Willett.
hold on, just one second. $1,923
Yes,
to whom?
James Willett.
Okay.
Oh my God. Do you guys see what I see? Do you guys see this right here? Can y'all see my mouse? Do you guys see that? This is so court. This is so only in court. Only in court. Do you guys see that? Let me know if y'all can see what that is, and let me know in the chat what you think I'm circling with my mouse there.
$2,500 to Yoko Willett.
How do you spell the first name?
YOKO.
Mr. Patrick, have you seen this?
I have, Your Honor.
Okay, what's your position in regards to the restitution?
They had the documentation. We're
I'm with you on that.
Okay, State, I'm gonna need you to file that documentation, because pursuant to statute, pursuant to the new case law, I can't order restitution without documentation.
Yes,
Mhm.
All right? Ms. Michaels, what, if anything, would you like to say before I pronounce sentencing?
Okay, this is important because if she's going to withdraw her plea, I want to point something out. First of all, I want to back it up so we can take a look at those DVDs. There they are. It looks like one of those. I mean, I haven't seen anything like this in like decades, but you could buy this and you can see how like half of them are used, but they came in on a spindle like that with a plastic thing. They're blank DVDs. I'm honestly surprised that they are not like VHS tapes. I'm surprised they've made it all the way up into like only being 2 decades behind, but like only in court though, right? So, okay, so let me go back to where we were here because this is important in terms of the rules for this. So
They had the documentation.
Pursuant to the new case law, I can't order restitution without documentation.
yes, ma'am.
All right? Ms. Michaels, what, if anything, would you like to say before I pronounce sentence against you?
before I pronounce sentencing, what, if anything, would you like to say before I pronounce sentencing? So literally, if for in any case, if a defendant pleads guilty and they want to withdraw their plea and they have to have one of those good, you know, one of those reasons like we've talked about, a good cause reason, you know, this would be literally that last opportunity. Because where we're at is we're at the sentencing proceeding. They've discussed the terms, they've discussed the restitution, this and that, time served. But the key part is this.
All right? Ms. Michaels, what, if anything, would you like to say before I pronounce sentence against you?
Before I pronounce sentencing. So she's within that window still. Okay. There's so much I want to say.
Jonathan was very special for me, and I know
I guess this is the dude she murdered,
no
maybe?
matter what I say at this moment, I know right now no one in the family is going to believe me. I know right
Oh,
now
dear.
no one in the family feels that I am innocent at any point, and I understand that. But I can actually prove my innocence.
Oh boy.
I actually can. And
Oh boy.
I'm not going to stop fighting to prove my innocence.
Oh boy.
I have more than enough. And Jonathan deserves to have the actual person who's guilty
Wow.
behind bars. I was helping Jonathan. I can show that I was trying to help him, and
Help him?
this
What?
I
Now I'm
know is
interested.
hurting the family, and I can see it in your faces, and I know your hearts
I wish we could see their faces. I wonder how they're looking at her.
are angry, and they should
Don't be
be.
hating. Welcome.
And
Oh, that's sorry. That is fun. Don't be hating. I disagree. That is funny. Don't be hating says she did. That's good head. Just kidding. Not funny. No, I think that's funny. Good job.
angry for you. And this is not fair to you. This has been dragging out for almost 2 years. It's not fair to you. And it's not fair to his children. Any of them.
There you go.
And it's not right. It really isn't. It's not. I've seen so much that it's just terrible. The way that they manipulated and altered and deleted things is wrong. They
Oh, boy.
should not be able to do it. And they have. And for you to be able to look me in the eye knowing that the things are altered and
You pled guilty, man.
Ms. Michaels, you are not to address the state. You are to
I'm not
address me.
addressing
You are.
the state.
You're addressing
Oh, okay. Hold on. Let's back this up and see who is she addressing. Because, like, yeah, she's not allowed. That's correct. She can't address the state. She can only address the court. Let's see.
And for you to be able to look me in the eye knowing that the things are altered and
You pled guilty, man.
Ms. Michaels, you are not.
Having said that, the state talked back to her. They need to get scolded too. I wonder if the state's going to get scolded. Did you hear that? That was the prosecutor. You pled guilty, ma'am. See, now that's he shouldn't have said anything. His response, him saying that, definitely confirms that she was addressing him specifically. But his response is, would if the judge didn't intervene, it would have only exacerbated and, you know, it would have only made this dialogue between them two go on longer and get more whatever. Like, in other words, it would have encouraged it, right? You pled guilty, ma'am. Well, now she's going to be fucking defensive towards the state. Anyway, the judge intervenes. Let's see what happens.
To address the state. You are to
I'm not
address me.
addressing
You are.
the state. I
You're addressing Mr.
apologize.
Giordani. You are going to address me. What do
My
you want me to
apologies.
say? What do you want to say to me?
my apologies. I wasn't trying to address the state directly. It's just, I was told. I just told one thing after another, and I truly believed that we were going to do the right thing, and it just didn't happen. I am so sorry for all of this, but I am so sorry. But I didn't do this, and I didn't
my God.
know this would end up like this. I really didn't.
What do you think? What is that?
And I will forever apologize to the family that I don't know how to fix any of this anymore. I don't.
This is odd.
I keep listening to what everyone tells me is the best thing to do. Just
Is she kind of trying to hint at ineffective assistance of counsel? Well, okay. Sorry. I shouldn't be presuming that any of this is based on anything that would be like a proper argument to make on your own behalf to change a plea. But anyway, having said that, as I assess it from a legal perspective, what she just said could be, if someone was trying to actually make a solid argument here, could be grounds for, or trying to lay the groundwork for ineffective assistance of counsel. Is that what she's doing? Probably not. Like, yeah, Flash, can we find out what her diagnosis is?
do this and it'll work out this way and follow this advice and we'll do this. And I keep listening to the people because they keep saying this is the best advice.
The people? Which people? Which people? Your attorneys? Is ineffective assistance of counsel?
It doesn't turn out the way they tell me it will. And it just gets worse and worse. And I don't know what to do anymore. You
Judge, I'm not comfortable with this record. I'm willing to let her out of her plea if the court is inclined.
Oh, okay. I'm willing to let her out of her plea. This is getting fucking interesting, guys. Wow. The timing of this in the wake of everything we've just discussed at length from Bryan Kohberger and then our whole series on plea deals, this is blowing my mind. It's not even her asking to withdraw it. The state says we'll let her out of her plea. Holy fucking shit. Hold on. Let's back this up. And also, what are you referencing? No dog left behind with this. It sounds like there's some animals and then me being a squirrel, but I don't know. What are you referencing there? Right. I literally thought the same thing. Don't be hating. I literally thought the same thing. The people in her head, that's what I thought. I thought the same thing and I didn't say it out loud. But now I feel like, okay, great minds think alike, I guess.
tell me it will. And it just gets worse and worse. And I don't know what to do anymore.
Judge, I'm not comfortable with this record. I'm willing to let her out of her plea if the court is inclined.
I don't know how to face this.
She's not even interesting. She's like, that is, okay.
All right.
It's just, this wouldn't be appropriate.
No, this is definitely not appropriate. I do agree with that.
Completely understand.
Let's go to trial.
All right. Ms. Michael.
This is very interesting. I think he's not saying let's go to trial as in she says she's innocent and I'm trying to maintain her and I'm looking out for her rights. This seems to be more like he wants to punish her. And I'm wondering, depending on what state this is in, this is a first degree murder case. Is this a situation, Flash, we need you to get us the details. Is this a situation where this would have been a death penalty case? And is he saying, let's go to trial to punish her for her doing this? Because then she could get the death penalty. I don't know. Where's her attorney? Her attorney is there. He spoke earlier. This is wild. We need to find out what state this is in, because I'm really curious if this would have been a death penalty case. I mean, it probably would have qualified given what we've learned from this limited video, considering all the beheading, tampering with a corpse. You got that going on. Anyways, I'm very curious. Can I get her name from the description? Devin Michaels. Maybe it'll say here. Let's read this. Devin Michaels appeared in court on Thursday for her sentencing after she pleaded guilty to decapitating the father of her children and disposing of his head in the trash. Before she was sentenced, Michaels spoke to the court and claimed that she was innocent and could prove it. A judge interrupted her, stating that she was addressing the state. The judge later allowed her to exit her plea, so instead of a sentence, she's now going to trial. Well, we should fucking watch this trial. What do you guys think? But it doesn't say where this is. It just says Devin Michaels, Devyn. She's going to go to trial. I need to look this up though. I'm the whole thing about the state withdrawing it. This is wild. She didn't even say, yeah, I agree. I want to withdraw. She just said, I don't know how to fix this. I will say this much. Him saying we offer to withdraw the plea or whatever. And I think, again, he's doing this not to be kind. He's doing this because he's like, she'll get punished worse if we go to trial. That isn't enough. Like, she has to want that. Like, right. In other words, they can offer that and then she could deny it or say, okay, great, thank you. But she didn't do either one. She said, I don't know how to fix this. Oh my God. So they sure seem ineffective at the moment. Gretchen, yes, very astute. It's bizarre. Like, what are they doing? And all of this is improper. And they should have, in normal cases, they would have and should have prepped her on how to do this, on how to address the court, on how you're allowed to speak. And if which she did, deviated from that, they should have intervened before it got so out of hand. This is very odd in every way. I want to know everything about this, Twiz. You know what? Sounds like we're going to get to do that, because guess what? Sounds like they're going to trial. We need to find out, when is the trial? Where is this? And we need to follow this. Family got up and left. Oh dear. Did anyone clarify about the Phoenix birds? Anyways, you know, it's interesting though. So if Bryan goes off the rails and has a meltdown, I mean, like we were saying, the narrow circumstances in which a plea can be withdrawn before the sentence is handed down, we are watching that happen in real time. This is qualifying, but we're going to look up the bit about the prosecute. This is very crazy. Like all of this is like in the 0.00001% of cases, but now adding the fact that it was initiated from the prosecutor. I mean, this is like a once in a bazillion. So we're going to look it up. But also, I'm just seeing if any of you guys in the chat have found what state this is in and when there's a trial. Okay, looks like you haven't, so I'll do it. I will do it. Hang on. Okay, so she's in Las Vegas. She was arrested in Henderson, Nevada. I'm just wondering if they were seeking the death penalty. Hold on. I'm not finding that. However, it seemed I don't think there would have been a lot of information really available in this case until now, because now it's going to trial and now everyone is going to want to know. So just because I'm not seeing it doesn't mean it didn't happen. I'm just looking here. I don't even know. Let me take a look at something else real quick. Okay, Nevada does have the death penalty, but they have not carried out an execution since 2006. So they're in a standstill like many states. So Nevada is one of those states that still has the death penalty, but they have been unable to carry out an execution because they don't have enough drugs or lethal injection, that whole thing. So for that reason, they're likely not seeking the death penalty currently on any new cases. So, okay. So in other words, because that's what I was wondering. I was wondering, like, if she goes to trial, is this now a death penalty case? Okay, so that's the first thing. So now let's see if we can find a trial date. I mean, maybe they set that in the end of this hearing, but I'm just gonna look and see. I'm not seeing a trial date Googling this, but we'll see what happens in this hearing, and maybe they won't talk about it. I mean, an important thing to know, right? Like we've talked about a lot, the majority of pleas happen early on. So it kind of depends, right? If this was where this case was postured, if this was kind of early on in the case and she pled early on, like a lot of people do, then it might be trial might be a ways out. But if she did the 11th hour plea, which is what usually the other portion of people do, is the 11th hour plea, then in that case, that would have meant they were ready to go to trial right meow. But then at the 11th hour, she took a plea deal. So that's why I'm talking about that, because we could kind of determine, if we can figure out where the case was postured, we might be able to figure out, like, are they going to be going to trial soon, or is this like a ways out? Okay, but maybe they will discuss it in the hearing. So there we go. Nevada. The agreement was that she would get life with a chance of parole after 15 years. Right in line with our discussion. You guys, let me know in the chat. Looking at this plea agreement, do y'all think she would be crazy to not take this? So, okay, so it seems like it's not death penalty. So I would imagine, right, if she takes this to trial and she's found guilty, it's probably LWOP, right? Probably LWOP. The plea agreement is life with a chance of parole after 15 years. Do y'all think she would be crazy to take this to trial just based on the agreement alone? based on the agreement alone. Because as we know from everything that we covered extensively in our 5-part series of plea deals, the discrepancy in terms of the risk from what could happen at trial versus what state is offering is like the main reason, overwhelmingly, why people decide and why attorneys advise whether or not to accept a plea. Has nothing to do with guilt or innocence. Okay, that was not a factor when you looked at the percentages. The main factor was exactly this, the discrepancy in terms of the risk. So what do y'all think? Should she like, just without knowing anything else, just looking at the risk being, let's say it's LWOP and the agreement is life with a chance of parole after 15 years. What do y'all think of that? And because this is a great example of literally what we were talking about. AR, what's AR? Like an automatic rifle? I don't know that. And I still don't know about the Phoenix birds and whatever that was about. And then I'm sure there's other things I don't know about. I've clarified the ICE agreement. It's not Blue Bonnet or Blue Basket or Blue Bunny. It's Bluebell. See, there you go. There you go, Kane. I got it. Got it. 15 years. Yep. And we heard at the very beginning of this, she's got a fuck ton of time served, guys. They were tallying it up. It was like almost 500 days. So that's what? Almost 2 years time served. So of the, you subtract that. So the 15 years becomes more like 13 years. If I heard that correctly, for how much time she's been in custody. And actually, having said that, if that's her time served, that would partially probably answer the question of where the case was postured. And I would imagine probably closer to going to trial, given that much time now that I think about it. So thank you for bringing that up. Take it, right? For real. Okay, let's keep watching.
Judge Mr. Giordani says that he's willing to let you out of your plea and he's willing to try this case. And you understand that he's willing to try this case on an open murder. So a jury can convict you of a first-degree murder.
There it is.
You understand that? Or do you want to talk to Mr. Patrick about it?
I don't want to talk to Mr. Patrick. He didn't listen to anything I said.
Oh, fuck, Mr. Patrick. That's the shitty defense attorney. Holy shit. I can't say I don't disagree with that. I do think that she is well-founded in her, like, Mr. Patrick sucks
First-degree murder.
opinion.
You understand that? Or do you want to talk to Mr. Patrick about it?
I don't want to talk to Mr. Patrick. He didn't listen to anything I said.
Ms. Michaels, I need you to understand what I'm saying to you and answer my question. Do you want to withdraw your plea and go to trial?
Yes, please.
All right. This plea is going to be withdrawn. Ms. Patrick, I need you to have some discussions with your client about.
Your Honor, I've moved to withdraw at this time. This case needs to go back to the.
Oh my God. Well, this is a shit show. Dude, the shit show alone is reason to follow the trial. There's Mr. Patrick. We know he sucks. Oh my God. What is going on?
He is going to be withdrawn. Ms. Patrick, I need you to have some discussions with your client about.
Your Honor, I've moved to withdraw at this time. This case needs to go back to the appointed counsel.
Ms.
I will.
Michaels, hold on just one second. Ms. Michaels.
Wait. Sorry, let me clarify something. Did y'all hear him say he moves to withdraw? He's not saying withdrawing the plea. He's moving to withdraw himself as counsel, which means oh my God. The implications of that mean that then she basically gets to start over because now y'all know, right? She has, like, what is happening? Oh my God. Oh my God.
This plea is going to be withdrawn. Ms. Patrick, I need you to have some discussions with your client about.
Your Honor, I've moved to withdraw at this time. This case needs to go back to the appointed counsel.
Ms.
I will.
Michaels, hold on just one second. Ms. Michaels, you need to conduct yourself like this is a courtroom. If you cannot do that, then they're going to remove you because I still have business to conduct.
Yes.
Do you understand? Mr. Patrick?
Judge, respectfully, I move to withdraw and have this case sent back to Office of Appointed Counsel.
Oh my God.
I am not in a position to accept appointment on this case should it go to trial at this time.
All right.
Oh my God.
All right, I'm going to have to reach out to the Office of Appointed Counsel and get
Oh my
a
God.
lawyer that's going to be appointed with the understanding this case is 2 years old.
Okay. So, well, 2 years old. I mean, this is good, dude.
So this case is not going to sit stagnant and wait around for a trial. So I'm going to reach out to Ms. Bush myself and have a discussion with her in regards to the appointment of counsel, because this is not going to be, this case has been delayed extensively, and this case is not going to further be delayed so that there is no justice for everybody.
Yes, Your Honor.
And Your Honor, if I may,
Oh my
that's
God.
one of the other reasons, because with Barry Edwards, it would be late
Sounds like he's drunk, this Mr. Patrick guy.
next year before I would even consider putting this on as a trial.
Well, I'll reach out to Ms. Bush.
Understood.
Oh my
July
God.
31st, 9 a.m.
And Your Honor, do you grant my motion to withdraw, please?
Yes, I'm going to grant your motion.
He doesn't even, his motion. Are you not gonna, what is going on? Well, I have so many questions. My first big question started out with the DVDs, but like, what is happening? Are we in a court where you can just say shit and it's like granted? Like, what about a written pleading? A motion to withdraw as counsel is a huge deal, and it's very difficult for that to be granted. This is, my mind is blown right now. Is this fake? Is this fake? Is this fake?
Ms.
This
Bush,
is not how this works.
Understood.
July
Where you just
31st,
ask for it, something like that. Like what?
9 a.m.
And Your Honor, do you grant my motion to withdraw, please?
Okay, first of all, something's happening on July 31st at 9 a.m. and we need to know what that is.
Well, I'll reach out to Ms. Bush.
Understood.
July 31st, 9 a.m.
And
I guess they're gonna have a status hearing at that point. Oh my God,
Your Honor, do you grant my motion to withdraw, please?
Yes, I'm going to grant your motion.
what is happening?
Thank you.
How? Thank you. Okay, all right, done. What? Oh my God. Oh my God. Well, we're gonna get all the tea if this goes to trial, which it looks like it is. Here's what I will say.
And
Oh my
let's
God.
talk about
Oh my
one-
God. That dude. Here's what I will say. I just was looking at everything on. This is wild. There is everything about withdrawing a plea, guys, deals with the defendant. Like the process. I don't understand how the prosecutor was allowed or able to make that decision or offer like that first of all, and then also this whole bit about withdrawing as counsel. Like none of these things are real. But looking at like as far as the withdrawing a plea, I mean, literally, it's everything that we've already read and talked about extensively, right? Of before sentencing, a defendant can withdraw it, right? After sentencing, you need manifest injustice, right? And the prosecutor's role: prosecutors cannot unilaterally withdraw a plea after it's been accepted by the court. Let me read that again. Prosecutors can't unilaterally withdraw a plea after it's been accepted by the court. Well, and it's been accepted by the court because we were at sentencing. What is happening? Now, it does say they can seek to withdraw the plea if the defendant violates the terms of the plea agreement, but I don't think that what happened in court today was, or whatever this was, violated the terms of the plea agreement. I mean, I can say with 100% certainty that it didn't. There's no way that, anyways. So that would be the only reason, as we know, right? If they violate the terms of the plea agreement, sure. But like, that's the only reason. What is going on? Like, for example, let's just say that you're in a case where you've got a number of co-conspirators, right? And you take a plea deal, and part of your plea deal is like, you're going to cooperate and testify against another person or whatever, right? And then you decide, yeah, I'm not going to do it. I mean, where I work, we have a number of cases where literally has happened, where we have clients who were the person who was supposed to take a plea deal to testify against somebody else. And then they withdrew that plea on the eve of the day they're supposed to testify. And then their plea deal got revoked. So that of course, right? If you violate the terms of the plea agreement, no plea, right? But that is not the case here in Nevada with this lady. This is wild. I don't know. I'm still doubting that this is real, this juncture. She was no. She was being did you not watch it, Twiz? She was being sentenced. She didn't take her plea back. Do we need to watch it again? Maybe we need to watch it again. Hang on. Let me see if I can pull it back up. She was being sentenced. She went crazy. The prosecution offered to withdraw the plea. She didn't actually even, did she even ever answer the question? Basically, it seems like everyone made that decision without her. Anyway, hold on. This was a lot to take in, I will say. What? 1 second here. Okay. 1 second. Let's just.
This advice and we'll do this. And I keep listening to the people because they keep saying,
There's the people.
this is the best advice. It doesn't turn out the way they tell me.
That's what it seems like.
And it just gets worse and worse. And I don't know what to do.
Oh, Heather just got here. Should we watch it from the beginning? Heather, have you seen this yet? Maybe we need to watch it from the beginning. This is insane. Heather, you're going to lose your mind. Let's just watch it from the beginning because it's short and we're going to be following this trial. And we're going to be following what else happens. This is wild. This is in Nevada. For anyone who's just getting here, this is Nevada, first degree murder. Let's watch. This is insane.
Go on page 6, C, 377239, State of Nevada versus Devin Michaels. May the record reflect that Ms. Michaels is present in custody. Ms. Patrick is here on her behalf. Mr. Giordani and Ms. Griffith are here on behalf of the state. Mr. Dave comes up for sentencing. Are both parties prepared to go forward?
Yes, Your Honor.
All right, state, this is.
I just want to say, don't be hating. Sums this up very accurately. The prosecution took the plea back and she seemed happy with it and her ineffective lawyer quit. Yep. That's just about that. That's a very astute way of summarizing.
A stipulated sentence. Anything you want to add?
I do just a couple of things, Judge. First, we have 3 victim speakers. I asked if they permitted me speak last.
Okay.
We obviously went to a settlement conference. We stipulated this sentence. I think that the life tale reflects the gravity and the haunting nature of the facts. As you know, the defendant not only murdered her ex, but then desecrated his body by decapitating him and putting chemicals on his body, causing it to burn. The defendant admitted to the fatal blow. She never admitted to the decapitation portion, but the evidence was overwhelming that it was obviously her who did it. Another haunting fact and something that should be concerning, which supports the life tale, is that the defendant had a corollary child abuse case that pre-existed this. We reviewed, Ms. Griffith and I reviewed the minutes in that case, and it appears that 2 days after she murdered and decapitated her ex, she appeared in court in front of another judge in this courthouse and made representations that she was staying out of trouble and obviously had that on her conscience at the time, walked right back out of the courthouse, and then ultimately was developed as our suspect and arrested. We take this case very seriously, obviously the family does as well. We believe the sentence reflects the gravity of the crime, so we will submit it. We do have some updates on CTS, which was wrong in the PSI.
Correct. I calculated the credit at 455 days as of today.
Okay, that sounds correct.
Okay, there's the time served.
Calculated in regards to she was on probation when this offense occurred. She then got that sentence imposed. She was released on that sentence, so she started accumulating the credit on that day. And I have it at 455 days as of today.
Yes, and we also have restitution requests. We've now received documentation.
Actually, I have received documentation.
Right, we just received it this morning. We showed it to Mr. Patrick.
Mr. Patrick.
It's supposed to be 5,000 to VOC,
I have that.
1,923 to James.
There you go,
Willett.
Flash.
Hold on, $1,923
Yes,
to whom?
James Willett,
Okay.
and $2,500.
I will just say that the title of this is doing this, is underselling this video. Woman accused of cutting off boyfriend's head fights with judge in hearing. Long crime. Get your act together. Are you kidding me? People are not going to watch this because they're going to see this title and be like, yeah. Tell them it happens every day. A person fighting with a judge, someone cut someone's head off. Yeah, just a normal day. Come on, get it together, long crime. That is totally not even an accurate description of what's happening here.
You'll go with that.
How do you spell the first name?
Y-O-K-O.
Mr. Patrick, have you seen this?
I have, Your Honor.
Okay, what's your position in regard to the restitution?
They had the documentation, we're okay with it.
Okay.
Meanwhile, I'm not entirely, I can't say with 100% certainty that he's also not maybe somewhat under the influence, this Mr. Patrick.
I need you to file that documentation because pursuant to the new case law, I can't order restitution without documentation.
Yes, ma'am.
All right? Ms. Michaels, what, if anything, would you like to say?
Here we
before I
go.
pronounce sentence against you?
Before sentence is pronounced, right? Oh God, here it goes. You know, it's really funny because it's like as soon as she does this, you know what's coming. When she says the look in her eyes and the way she says this, you're like, oh no.
Against you.
Oh God. Oh God. Oh dear.
Jonathan was very special, very unique, and I know no matter what I say at this moment, I know right now no one in the family is going to believe me. I know right now no one in the family feels that I am innocent at any point, and I understand that. But I can actually prove my innocence.
There we go.
I actually can. And I'm not going to stop fighting to prove my innocence. I have more than enough. And Jonathan deserves to have the actual person who's
What's
guilty
happening?
behind bars. I was helping Jonathan.
Hold on. Sorry. Don't be hating. This is wondering why Nightbot said wrong. That's Heather's command. That's why. So Heather, this is a long story that has to do with our channel troll, the one troll from a long time ago. But when Heather's command says wrong, and then James's command says right. So that's why. But great question. I'm glad you asked.
I have that I can show that I was trying to help him. And
By cutting off his head.
this I know is hurting the family, and I can see it in your faces, and I know your hearts are angry, and they should be. And I'm angry for you. And this is not fair to you. This has been dragging out for almost 2 years. It's not fair to you.
Oh my God.
And it's not fair to his children. Any of them.
Now coming up, she's going to start addressing the state, and the state talks back to her.
And it's not right. It really isn't. It's not. I've seen so much that it's just terrible. The way that they manipulated and altered and deleted things is wrong. They should not be able to do it. And they have. And for you to be able to look me in the eye knowing that the things are altered and
You pled guilty, man.
Ms. Michaels, you are not to address the state. You are to
I'm not
address me.
addressing
You are.
the state. I
You're addressing Mr.
apologize.
Giordano. You are going to address me. What do
My
you want me to
apologies.
say? What do you want to say to me?
my apologies. I wasn't trying to address the state directly. It's just, I was told.
I mean, Mr. Patrick, what the fuck are you doing?
I just told one
I will say, I don't think she's I would say that she's better off with him withdrawing. Although that entire thing is beyond me.
thing after another. And I truly
It was just one thing after another. Oh no, sorry. She's saying I was told one thing after another. Okay.
believed.
Yeah, Mr. Patrick is there. Yep, Mr. Patrick is there. You'll hear from him shortly when he withdraws as her counsel spontaneously and with nothing in writing.
That we were going to do the right thing, and it just didn't happen. I am so sorry for all of this, but I am so sorry. But I didn't do this, and I didn't know
Wait for it.
this would end up like this. I really didn't. And I will forever apologize to the family that I don't know how to fix any of this anymore. I don't. I keep listening to what everyone tells me is the best thing to do. Just plea and follow this advice and we'll do this. And I keep listening to the people because they keep saying, this is the best advice. It doesn't turn out the way they tell me it will. And it just gets worse and worse. And I don't know what to do anymore.
Judge, I'm not comfortable with this record. I'm willing to let her out of her plea if the court.
All right, there's the the prosecution moves to withdraw the plea, and the only thing that what the law says is that in terms of the prosecution's role of a plea withdrawal, once a plea has been entered and accepted by the court, the only time that the prosecution can withdraw a plea, right, is if the plea is violated, like we were talking about just a few minutes ago. If they violate the terms of the plea agreement, then yeah, again, that's fine. I don't understand any of this. I
don't know how to fix this.
And she never says she wants to withdraw the plea.
All right,
It's just, this wouldn't be appropriate.
I completely understand.
Let's go to trial.
It wouldn't be appropriate, he says. It wouldn't be appropriate. And the judge says, I completely understand. He says, let's go to trial.
All right. Ms. Michael jumps down. Mr. Giordani says that he's willing to let you out of your plea and he's willing to try this case. And you understand that he's willing to try this case on an open murder. So a jury can convict you of a first-degree murder. You understand?
Remember, the plea they offered her was 15 years and then for probation or whatever, like 15 years. What was it? Probation after 15 years, but she's got like 2 years time served.
Isn't there? Or do you want to talk to Mr. Patrick about it?
Well, I don't want to talk to Mr. Patrick. He didn't listen to anything I said.
Miss Michaels, I need you to understand what I'm saying to you and answer my question. Do you want to withdraw your plea and go to trial?
Yes, please.
Okay, she says yes. So never mind. She says yes, please. It was hard to understand her because of all the crying. She says yes, please. Now, having said that, this doesn't count. There needs to be a formal colloquy where she's not hysterical. This is a huge fucking deal. All of this is done. Look, we've only got like a minute and a half left in this video. There's nothing in writing in any of this. This whole thing, a lot of decisions are made here. First of all, the state moves to withdraw a defendant's plea without them violating the terms of their plea agreement. You have her kind of accepting it in hysterics. She did say yes, please, but I mean, this is not sufficient. And then you have counsel withdrawing and it being granted. Like, you guys, what? I still don't fully accept that this is real.
He didn't listen to anything I said.
Miss Michaels, I need you to understand what I'm saying to you and answer my question. Do you want to withdraw your plea and go to trial?
Yes, please.
Yeah, flash.
This plea is going to be withdrawn. Ms. Patrick.
Hear it? Just like that. This plea is going to be withdrawn. What? Are you fucking kidding me? No colloquy, nothing in writing. I can't.
You to have some discussions with your client.
Here we go.
Your Honor, I've moved to withdraw at this time. This case needs to go back to the
He moves to withdraw as her counsel.
appointed counsel.
Miss
I will.
Michaels, hold on just 1 second. Miss Michaels, you need to conduct yourself like this is a courtroom. If you cannot do that, then they're going to remove you because I still have business to conduct.
Yes.
Do you understand?
Exactly, Heather. This is why I'm like, is this real?
Mr. Patrick?
Judge, respectfully, I move to withdraw and have this case sent back to Office of.
So y'all know how difficult it is to withdraw as counsel for a criminal trial. Like this, it's, yeah, we've all seen it. You have to have, it's a lot. There has to be a lot of documentation. There's a lot of back and forth. You have to show good cause. You have to state your grounds. This is like, it's really difficult, right? And we have a spontaneous him withdrawing as counsel.
Appointed counsel. I am not in a position to accept appointment on this case should it go to trial at this time.
All right. All right, I'm going to have to reach out to the Office of Appointed Counsel and get her a lawyer that's going to be appointed with the understanding this case is 2 years old. This case is not going to sit stagnant and wait around for a trial. So I'm going to reach out to Ms. Bush myself and have a discussion with her in regards to the appointment of counsel because this is not going to be, this case has been delayed extensively, and this case is not going to further be delayed so that there is no justice for everybody.
Yes, Your Honor.
And Your Honor, if I may, that's one of the other reasons, because with Barry Edwards, it would be late next year before I would even consider putting this on as a trial.
Well, I'll reach out to Ms. Bush,
Understood.
July 31st.
That's her attorney with the mustache. That's her attorney with the mustache, Mr. Patrick. That's her attorney with the mustache, Mr. Patrick. Hold on. Let me look, guys, this is the prosecution. Can y'all see my mouse? The bald dude and the lady with the blonde hair who Twiz somehow thought was Ann Taylor for some reason. That's the prosecution. Okay. Right now, the female prosecutor is blocking our view of Mr. Patrick. Mr. Patrick is next to the defendant because why? He was her defense attorney.
Yes, Your Honor.
And Your Honor, if I may, that's one of the other reasons, because with Barry Edwards,
Yeah.
it would be late next year before I would even consider putting this on as a trial.
Well, I'll reach out to Ms. Bush,
Understood.
July 31st, 9 a.m.
And Your Honor, do you grant my motion to withdraw, please?
I mean, he sounds drunk. Do you grant my motion to withdraw, please? Just watch.
Yes, I'm going to grant your motion to withdraw.
What is happening?
Thank you.
I can't, this 9-minute video, I feel like it's still, this is like, do we need to watch it a third time? I still can't wrap my head around all that is going on here. Is this? And let's not forget, where is it? Let's not forget to appreciate the DVD stack, because that's a whole thing. Where is it? Yeah. See over here? The big stack of blank DVDs. There's that. I remember those days from like 20 minutes ago when we were at the beginning of this video, and I thought this was the craziest part of this video, the DVDs. Those were the days. I remember the days. Oh, I was so young back then. Y'all. I just
Cannot do that, then they're going to remove you
What is
because I
happening?
still have business to conduct.
Yes, yes.
Do you understand?
I know, Heather.
Mr. Patrick?
Judge, respectfully, I move to withdraw and have this case sent back to Office of Appointed Counsel. I am not in a position to accept appointment on this case should it go to trial at this time.
All right. All right, I'm gonna have to reach out to the Office of Appointed Counsel and get her a lawyer that's going to be appointed with the understanding this case is 2 years old. This case is not going to sit stagnant and wait and wait and wait around for a trial. So I'm going to reach out to Ms. Bush myself and have a discussion with her in regards to the appointment of counsel, because this is not going to be, this case has been delayed extensively, and this case is not going to further be delayed so that there is no justice for everyone.
I mean, and again, having said that, I'm with you, Flash. That this judge, there's a lot of issues with this judge. I mean, this is not normal, but also like I literally was saying right before this judge said this, the first time we watched this, I was literally saying like, oh well, now it's going to be years before a trial, because if she lets Mr. Patrick off the case and she gets new counsel, well now it's going to be years, right? But no. In the one exception to all of the rules, apparently, this judge is like, nope, we're not going to delay it.
Yes, Your Honor.
And Your Honor, if I may, that's one of the other reasons, because
There's Mr. Patrick again.
Barry Edwards, it would be late next year
Who
before.
the fuck is Barry Edwards? Who the fuck is Barry Edwards?
One of the other reasons, because with Barry Edwards, it would be late next year before I would even consider putting this on as a trial.
That sentence doesn't make any sense.
I'll reach out to Ms. Bush,
Understood.
July 31st, 9 a.m.
Something's happening on July 31st, and we're going to be on the lookout for that.
And Your Honor, do you grant my motion to withdraw, please?
What is happening?
I'm going to grant your motion to withdraw.
Thank you.
I don't know that there's ever been a moment in history where so much has happened in 9 minutes. Less than 9 minutes, honestly, because like that's pretty much you guys, y'all. Oh my God. Oh my God. she said, let's back it up to the yes, please. Okay. Remember, in normal life, none of this would be happening. In normal life, she would have to be the one moving to withdraw the plea, not the prosecutor. And in doing so, it would have been discussed with counsel. There would be something formal in writing. There would be an extensive colloquy. It would be a whole thing, and it would not ever be accepted when the defendant is in hysterics. Remember all these questions that we saw in the forms that we looked at, and then we heard them. You know, you have to answer all these questions like, are you of the state of mind? Are you of sound mind to make whatever the decision is, whether it's accepting a plea, denying a plea, whatever the case is? When you make a decision as a defendant, they ask all those questions. Being in hysterics like this, in my mind, automatically like invalidates anything that's decided by her right now, right? First of all, this is not ever how this should be done. Even if she wasn't in hysterics, the fact that there's no colloquy, there's nothing in writing, and the fact that it was the prosecution moving to withdraw, none of that's by the law. None of that's legal. That's not. But the closest she comes to agreeing to withdrawing the plea, which was not her idea, and again, she's in hysterics, and there's no colloquy, is there's one little moment where she says, yes, please. Let's hear that again, because that is the only time where that's the closest she gets, but that's not sufficient.
Discussions with your client, a plea is going to be withdrawn. Ms. Michaels, I need you to understand what
Okay, here it is.
I'm saying to you and answer my question. Do
Yes,
you want to withdraw your plea and go to trial?
yes, please.
All right.
I will just say, she's being all of her constitutional rights have been, I don't know what the status was of this case prior to this video, but whatever they were before, even if whatever, everything's been destroyed. All of her constitutional, in 9 minutes, they have completely, utterly destroyed a defendant's constitutional rights. All of them. Like, this is, what?
Listen to anything I
Miss,
said.
first degree murder. You understand that? Or you want to talk to Mr. Patrick about it?
I don't want to talk to Mr. Patrick. He didn't listen to anything I
Miss
said.
Michaels, I need you to understand what I'm saying to you and answer my question. Do
Yes,
you want to withdraw your plea and go to trial?
yes, please.
All right. This plea is going to be withdrawn. Ms. Patrick, I need you to have some discussions with your client
Your
about.
Honor, I've moved to withdraw at this time. This case needs to go back to the appointed counsel.
Ms.
I will-
Michaels, hold on just one second. Ms. Michaels, you need to conduct yourself like this is a courtroom. If you cannot do that, then they're going to remove you because I still have business to conduct.
Yes, yes.
Do you understand?
Here's the other thing. Remember, prior to this, we don't know. I mean, maybe there's other videos. Prior to this, what should have happened is there should have been a hearing with actual papers in writing with a colloquy, right? Like, in other words, what we saw with Bryan Kohberger in the change of plea hearing, there should have been one of those already for this, right? Like what Bryan Kohberger has coming up on the 23rd, sentencing after plea deal, that's her in this video. That's her sentencing. So prior to this video, there should have been a hearing where they went through everything thoroughly. Now, do I have any confidence that was done given what we've seen today? No, I don't, but that's what should have been done. In which case, she would have to admit that she committed the crime. She would have to say, I'm knowingly and voluntarily accepting this plea. She would have to say, I've reviewed all the discovery. She would have to say, my counsel has advised me and da-da. You guys have seen it all. And you guys know it's like the colloquy is lengthy and extensive as it should be. And all of that should have been, triple, quadruple checked and gone over in the hearing. And then the judge accepts the plea. Why? The judge accepts the plea because A, both parties have agreed to the plea, but also it's based on the defendant's colloquy. If the defendant says, no, I don't accept the plea, or they say, no, I'm not guilty, or they say, no, I was under the influence, or I haven't had enough time to review all the discovery. If they answer no to any of those questions in the colloquy, no plea. Sorry, let me just be clear. The judge will not accept the plea. Okay. Once the judge has accepted the plea, which has already happened prior to this video, because this is the sentencing, you're in that new phase of the plea's been accepted. Does that make sense? And remember, the only grounds for the prosecution to withdraw a plea are if the terms of the plea have been violated. Now, the terms of the plea, okay, the terms of the plea are different than her colloquy, right? The terms of the plea are what they agree to, which is in this case, from what we have seen here, the terms of the plea was, instead of going to trial, right, and facing life in prison, the terms of the plea are you plead guilty and you get 15 years and then probation or whatever, okay? That's the terms of the plea. And so that's basically it. Now, in other cases, I can give you an example of the client that was in federal court today. Okay. In other cases it's a little bit different. For example, the client that was in federal court today, he had a plea agreement for the indictments that he came down in like 2023. Okay. And he was released on bond, and it wasn't not easy to get him out on bond. Okay. Part of the terms of, and then he made a plea deal. He went ahead, and part of the plea was like he was going to provide information about a co-defendant, which he did, and it was really helpful, right? But the other terms of the plea and of all this were like, don't commit more crimes, no more criming, don't do the crimes. And it like specifically set out in the agreement the crimes that he had already done. It had been a pattern. It's like, you can't do this again. Kind of like, I'll give a great example that will make it easy to understand. Kind of like if you get a DWI, right? And then they give you your license back or whatever it is, right? They're going to be like, but you can't get another DWI, right? It's kind of like that. Okay. So that type of shit only applies though if you're in a position where you can continue doing the criming. So for example, in like her case or Bryan Kohberger's case, all of those conditions aren't actually part of the plea agreement. So the plea agreements are actually far more simple when you don't have all those other conditions, right? Again, I'll give another example. And again, we've got clients that we represent that are like this. You've got co-defendants in a case. Okay. There's a plea agreement. One, for example, our client got a really great deal, a phenomenal deal. And the plea agreement was testifying in this other defendant, the co-defendant's trial, testifying as the star witness, right? In that co-defendant's trial and being the star witness. And basically the majority of the prosecution's case hinged on having this key testimony. Okay. Well, on the eve of that trial, according to our client, the co-defendant had put out death threats on our client and the client's family. And literally, according to our client, he was afraid for his life. And due to being afraid for his life, he withdrew his plea. Now, the terms of that plea were he had to go and testify, okay? And if he had followed through with that plea, the plea deal that he was given was amazing. It was like maybe time served, okay? Well, because he violated the terms of that plea agreement by not providing that testimony, he violated the terms of that plea, no more plea deal. And now he's back in custody. Or I guess he's in custody, and now he's back looking at first-degree murder and headed for trial. So does that make sense? Am I answering y'all's questions, hopefully in a way that helps? So in other words, all of this shit that went down here today, this lady right here, for whatever you can say about her, she didn't violate their agreement. The plea was already accepted by the court. The plea was already accepted by the court. The reason why the plea has now been thrown out is because of the prosecution withdrawing it. The prosecution didn't even allege that she violated the plea. They just said, we withdraw it. And he actually says it's actually even worse. He's like, this isn't proper. Like, let's just watch this again, because this is insane. It's worse than any of the other potential ways that it could have gone down. Okay, let's watch.
And I will forever apologize to the family that I don't know how to fix any of this anymore. I don't. I keep listening to what everyone tells me is the best thing to do. Just do this and it'll work out this way, and follow this advice and we'll do this. And I keep listening to the people because they keep saying this is the best advice. It doesn't turn out the way they tell me it will. And And it just gets worse and worse.
Sorry, I just saw what Twiz said in the chat. When Henderson police spoke to Michaels around the same time, she told them that she did not live with Willette, but that they were in the process of moving in together to make it easier on their children, document said. However, this move was complicated because Michaels was married and lived with Willette's son, making him both her husband and stepson. Oh my God. It's like a Glendy and a Wenda. Holy shit. Twiz, you win. You win. I'm trying to wrap my head around this. What the? Oh Lord, I will say, given that bit of facts there, I think that had we known that part first, we maybe could have seen where this was headed to a certain extent. Maybe not all of the gross violations of her constitutional rights, but like the shit show ahead of us, right? That foreshadows the shit show. What is happening? Yeah, exactly. It's how Hollywood would depict it. Yeah, I know. He jumped to conclusions about her wanting a deal. Are you referencing Mr. Patrick? I don't know. The thing is like, I'm not entirely positive that he's not also drunk. So, is it jumping to conclusions? Is he just shit-faced? Is he just drunk? Is he ineffective, or is he inept, or is he all of the things? Could be all of the above. Could be all of the above. Is he even a lawyer? Because honestly, what he did today in this is not anything a normal lawyer, like not intervening with all this. Oh, okay, let me back up. There's literally nothing that Mr. Patrick has done in this video that is anything a lawyer would do ever. So I don't know.
I don't know what to do anymore.
Judge, I'm not comfortable with this record. I'm willing to let her out of her plea if the court is inclined.
I'm not comfortable with this record. I'm willing to let her out of the plea.
I don't know how to face this.
All right.
It's just, this wouldn't be appropriate.
All right.
This wouldn't be appropriate. So there's nothing like she violated. It wouldn't be possible anyway, right? The question of is she violating the terms of her plea? Like that question doesn't apply here because of the phase that this is at in this whole process. So this is not a legal standard, right? We see what's on the screen right here. Like that is not anything. That's not grounds for anything. It's just this wouldn't be appropriate. I cannot figure this out. That's not anything. Oh, you know what? Like what I was just saying about Mr. Patrick, now I'm starting to wonder, are any of them actually lawyers? Even the judge. Did anyone in this room go to law school? Has anyone in this room passed the bar? Right. Because that was like the only explanation for what we're seeing.
I don't know how to face this.
All right.
It's just, this wouldn't be appropriate.
I completely understand.
Let's go to trial.
Mr. Giordani. All right. Ms. Michael jumps down. Mr. Giordani says that he's willing to let you out of your plea and he's willing to try this case. And you understand that he's willing to try this case on an open murder. So a jury can convict you of a first-degree murder. You understand that? Or do you want to talk to Mr. Patrick about it?
I don't want to talk to Mr. Patrick. He didn't listen to anything I said.
Oh my God.
Ms. Michaels, I need you to understand what I'm saying to you and answer my question. Do
Yes.
you want to withdraw your plea and go to trial?
Yes, please.
All right. This plea is going to be withdrawn. Ms. Patrick, I need you to have some discussion.
And here it is. The hysterical yes, please. So great question. Don't Be Hating says, so it was her husband's head or stepson? Both, because they are apparently the same person.
With your client about...
Your Honor, I've moved to withdraw at this time. This case needs to go back to the appointed counsel.
Ms.
I will-
Michaels, hold on just 1 second. Ms. Michaels, you need to conduct yourself like this is a courtroom. If you cannot do that, then they're going to remove you because I still have business to conduct.
Yes.
Do you understand?
This is crazy.
Mr. Patrick?
Judge, respectfully, I move to withdraw and have this case sent back to Office of Appointed Counsel. I am not in a position to accept appointment on this case should it go to trial at this time.
All right.
I know, we need to see. I'm gonna look.
All right, I'm gonna have to reach out to the Office of Appointed Counsel and get her.
I think
lawyer.
Flash said he looked and this was the only video. I know, now it's like, well, hold on. Why did she plead? Well, we've talked extensively about why in general people plead and don't, all the different things. But I don't know anything about this case apart from what we have all learned watching this one video, to where I could weigh in on any of the process that went on prior. Like, as far as her specific case, I mean, clearly there's ineptitude involved. I mean, the deal sounds great, right? Potential like life without parole, maybe, right? Versus 15 years and time. Like, it, that on its face, that deal is a good deal. On its face, that deal is a good deal. But I have no idea what evidence the state has. But again, referencing back to the studies that we covered in our series, the evidence or lack of evidence of the government is lower on the totem pole and not the deciding factor for everyone that was surveyed when it comes to deciding whether or not to take a plea. The number one reason was literally the disparity of the risk involved if you're convicted at a jury trial and the deal. So again, 15 years compared to life without parole. That gap is why you take the deal, right? Regardless of anything, that is why people take them. It's why in the studies, the attorneys say they will advise clients to take them. And remember, that's why one of the solutions offered by the author was, if you can narrow that window and decrease the disparity, then that could be a possible solution to the issues that come up with this whole thing about the coercive plea. And if anyone didn't see all that I think I would highly recommend, because we did a lot of deep diving into the nature of the plea, like hard fucking core, guys. Okay, so hardcore I don't even know how it's allowed on YouTube. Just kidding. Wrong type of hardcore. Anyways, I did not see the family get up and leave. Let me back that up. Oh my God.
Appointed counsel. I am not in a position to accept appointment on this case should it go to trial at this time.
All right. All right, I'm gonna have to reach out to the Office of Appointed Counsel and get her a lawyer that's going to be appointed, with the understanding this case is 2 years old. This case is not going to sit stagnant and wait around for a trial. So I'm going to reach out to Ms. Bush myself and have a discussion with her in regards to the appointment of counsel, because this is not going to be, this case has been delayed extensively, and this case is not going to further be delayed, so that there is no justice for everybody.
Yes, Your Honor.
And Your Honor, if I may, that's.
I maybe didn't go back far enough to see the family. So she said they were misrepresented to her. This is the exact reason why the colloquy matters. And it looks like we can't watch it. Because if that's why, when you make the plea, like I said, whenever there's any major decision that's being made for, if you're the defendant, that is why you do the colloquy. That's why you make it thorough. That's why you have it in writing. It's why you ask all those questions, because no decisions should be made when someone's in hysterics like this. And so here's what I will say. Let's just pretend that this is not this case, to where, let's pretend there was a thorough colloquy done. Let's just say she had competent counsel. Let's compare it to something like Bryan Kohberger, just as a recent example of what a plea hearing looks like. And the colloquy, like clearly she was in a better mental state, right? They were, went through all the questions. She said, yes, my attorney did this and that. Like, I saw, again, answering all the questions correctly, to where it's a knowing, voluntarily, and intelligent plea. She's not being coerced, all those things. If all that had been done here, then her saying things in hysterics are not going to override that. Because why? The reasons I just stated. If someone's in hysterics, that's not when it's exactly why they shouldn't be making these decisions. That is like not the moment when you trust what they're saying to make these huge decisions on the fly. That's why you have the colloquy there, right? And that's why you make sure that they're in the right state of mind and all the rest. So, does that make sense? Like, her in hysterics right now, if all of that was done prior correctly, that would still stand. Now, having said that, if during the colloquy, which would have been prior to this, and if she was in a different state of mind, let's just say that she was not in hysterics, right? If at that time, under those circumstances where you're going through everything, she's like able to be more calm and rational, what have you, and then she's like, oh, this was misrepresented, what would have happened was, at that time, the judge would not have accepted the plea. If it's like, oh, this was misrepresented, it's like, okay, well, let's withdraw it. And then you can either take some more time to figure this out or whatever. Like the judge shouldn't accept the terms of the plea, shouldn't accept the plea unless and until all of those things, like what we saw with Bryan Kohberger in terms of the form and the colloquy. We saw the same thing with the grand juror indictment just from last night. I mean, we couldn't watch the hearing because, again, in federal court, but we saw it on the forums. We read that. All of that has to be in place, right, for the judge to accept the plea. And then once that's happened, it means all those things were in place. Now, again, here in this particular case, I have concerns for obvious reasons that any of this was done, but it should have been done. Can I say it was done in this case? Absolutely not, because this case, I don't even know. Started with the blank DVDs and went haywire from there, basically. Plastic Pants, welcome. I think a new squirrel friend here. Welcome to the Squirrel Crew, where everything is squirrely, and right now this is insanity happening. I mean, I agree. Soap operas will never be relevant when we have reality. Facts. Literal facts right there, man. So yeah, this is the only proceeding that's been on cameras. Wow. No protocols are being followed by anyone. Also facts. And you know, again, with having none of the rest of this being televised up till now, there is literally, you know, talk about having confidence, right? Like, I have no confidence that any of this has been done correctly. And this is the only example I have of how this case has been conducted with this judge. And this is not even, I don't know. I don't even know. Was there even a colloquy? Was there even a plea that did they do any of it? Again, sorry, let me back up. I still have questions that anyone in this room went to law school or passed the bar exam. I have questions. I'm going to need proof on I'm going to need proof on that first before I can move on to the next set of questions I would have, you know? That's exactly right. Without cameras, it's hard to know what's happened. Yeah, exactly. How does she know a jury wouldn't exonerate her? She doesn't. I mean, no one can know for sure what a jury is going to do ahead of time. Again, that's not the deciding factor from what the studies show in terms of accepting a plea. It's the discrepancy in therefore the risk in how much of what you could end up being sentenced to if you get convicted, and then what is the terms of the plea. This is just, you know,
One of the other reasons is because of
he's got to be under the influence, and then he mentions this Barry somebody. Is this another imaginary person?
It's from everybody.
Yes, Your Honor.
And Your Honor, if I may, that's one of the other reasons, because with Barry Edwards, it would be late next year before I would even consider putting this on as a trial.
Well, I'll reach out to Ms. Bush,
Understood.
July 31st, 9 a.m.
And Your Honor, do you grant my motion to withdraw, please?
Yes, I'm going to grant your motion.
Thank you.
I'm still like, what motion? There's no motion. Oh my God. Oh my God. All right. With all of this having happened, and also I just am so in shock I couldn't type the word plastic correctly. With all of that, let's now go back to where we were, where, my God, here's what it's like to have order in the courtroom at the very least. Let's back it up so we can remember what was happening in this. Okay. Oh, right. I remember where we were. Where we were was I felt like Judge Hippler was being very, very, very kind to the defense in terms of how he's assessing their arguments. I thought their argument sucked here. So
Any longer at play.
That's
The
exactly
concerns identified by the defendant, while certainly not to minimize those. They are concerns, and they are significant concerns. I do not think, however, the non-dissemination order and the right of the public to information is outweighed or outweighs those rights, I should say. And frankly, I don't think that lifting the non-dissemination order will meaningfully impact those concerns. I mean, the media frenzy, as it has been described, will continue regardless. It is a little bit like water
Water no bridge.
will find low ground. In this case, the media is going to write about something regardless about this case. The lifting the
I mean, he's not wrong. Literally every single day since this happened, there's things coming out. But anyway, and plus you've got Steve Gonsalves, who just single-handedly does all the things. Also, I want to say thank you so much, Flash, for bringing up this video that we just watched. And that's how we ended up watching it. Like, had he not mentioned it, we wouldn't have watched it. So Flash, thank you for introducing us to a whole new world of injustice, but also some crazy shit show.
non-dissemination order does not require the counsel or others who were previously bound by it to speak. And the state has indicated they don't intend to until after the sentencing.
Can we narrow it down, though? Because I do agree with what the defense was asking. They were like, well, who's the prosecution, though?
I would hope that the media interests would respect those positions and give people the space that they need.
Yes, his demeanor is very different.
And request. In terms of,
Very different.
for example, the defendant's family and others coming and going at the sentencing, we intend to have, as we did before, appropriate security measures in place to ensure that they, as well as the victims, are allowed to get in and out unscathed by the media, if that's what they wish to do, or if they wish to speak to the media, they can do that as well. At this point, I just don't think that I can justify the continuation of the non-dissemination order. I think the rights of the public to information in this case is paramount, given the fact that a plea has been entered in this case, and so I'm going to lift the non-dissemination order. But I want to
here we go.
Point out.
Okay, before you get started this, you guys, what does anybody remember? Every time we've talked about when might the docs be unsealed, and also the unsealing of the docs versus the non-dissemination order. Does anyone remember what I've said in like the past 10 live streams about how I think it's going to work with the documents? How and when I think that we would start to seal, like when would they be unsealed? Does anybody remember what I've said a bazillion times? Anyone? Wait, why is No Dog leaving? Why would No Dog leave? Hold on. No Dog, we love you. Are you leaving? I'm confused. Twiz said you were leaving. I love it. Just can't keep. Wait, what are you saying? Oh, you're saying please come back every night isn't like this. Wait, please come back every night isn't like this. I'm not quite sure. See, that makes it sound like No Dog was leaving because the shit show was too much or something. Anyways, okay, so what I've been saying this whole time as far as the unsealing of the docs, right, is that it's separate from the non-dissemination order, and that I would expect it to happen over time. And that I would expect that after the sentencing, that things would slowly start to get unsealed or unsealed with redactions, and it would be a process. And that it would probably be several months before we started to see things changing. For anyone who, I'm sure it's on every live stream for the past like 6 live streams, probably more than once, but that's what I've said. So let's see what he says here.
What that means and what it doesn't mean. So obviously nobody's required to speak to the media, first of all. Second of all, I want to be clear that the court's prior preservation order to the parties is not lifted and continues to stay in place. And so it's important to understand that those obligations still exist. And then the other thing I want to point out is that by lifting the non-dissemination order, that does not convert sealed documents to unsealed documents. Documents previously sealed by the court are still sealed.
And so this is where I'm like getting really excited because I'm like, thank God he's finally, I don't know about everyone. Me, I know also Heather, many of us have been literally waiting for this moment. When is he going to address the sealed docs? And finally, guys, finally. Oh my God.
Now, I see the media also filed a petition to be heard to unseal everything. I'm denying that.
Yeah, obvious. I mean, that was, you can't ask for, the media did not make that request on a good faith basis, and they know it. Don't ask for things like that because you're going to just get flat out denied. You have to be reasonable. What you should be asking for is think about what is reasonable. What do you think a judge is likely to find reasonable? And then maybe you just ask for a tad bit more than that, but don't ask for, they literally said unseal everything right now all at once. Like, sorry, what are you, did you hang out with Mr. Patrick? And are you also intoxicated when you make that and you're bleeding? Like, dude.
Outright the request to intervene because I think it's premature at this point. So the court will its intent is to, after sentencing, begin the process.
Literally what I've been saying is what I expected to happen.
Reviewing all the sealed material in this case to determine what should be unsealed and what should not be unsealed. That process will include an opportunity for counsel to register any objections to unsealing documents, specific documents, and request to redact certain sealed documents before they are unsealed or
Yeah, yes, redact, yes.
seal them in a redacted form.
Yes, thank you.
I intend to do that in groupings of documents.
Yes, all of the, I have to just, this is what I was going to say. Like, whoever it was it Don't Be Hating said his demeanor is different in this hearing? It is. Here's what I have to say. I completely agree. I'm surprised I did not expect, prior to reading the filings that we read at the beginning of the live stream, I did not expect the NDA to be lifted just because, for the first and foremost, we're so close to sentencing. After we read the filings, I did expect it because the media won in their filings, okay? I did expect it. So there's that. And then I also expected, this is the answer that I expected, but what in essence, what I'm saying is this, and I haven't said this very much about Judge Shippler. I agree with all of his findings made in this hearing. I agree that given the pleadings, vacating the non-dissemination order was the right call, but given the pleadings, the media won, like I said. And I 100% agree. As much as I would love for everything to just be unsealed all at once right now, of course I would love that. But do I actually believe that's the right decision legally? No, of course not. 100% no. He has to go through all of these. There's a bazillion documents. And a lot of these were before he took over the case, right? He has to go through all of them, and it's going to be on a pleading by pleading basis, and again, especially too, because it's like, look, we want to take the least restrictive measure. That actually ends up being a lot more work because here's why. If it's just like either it's sealed or it's not, okay, that's a yes or no question. But the least restrictive measure could mean unsealing but redacting, and then you have to go word by word. It's not just the document as a whole, yes or no, it's word by word and redact. And that is the proper way to do it. That is the least restrictive measure. It's how it should be done. But it will take longer. But that is the correct way. I agree literally with all of the things he's saying. I think he's absolutely correct. This is 100% without question how this should be done. As much as it would be great for them all to be unsealed right now.
Documents, specific documents, and request to redact certain sealed documents before they are unsealed or unseal them in a redacted form. I intend to do that in groupings of documents at a time. As I sit here now, my thought is I'm going to start from newest to oldest because those are the ones that I have the most working knowledge of as to the reason for the sealing of the documents as well as the content of those documents. And so I think I can get through those more quickly. As we move backward in time, it's going to take further, more extensive review by the court to figure out, to obviously review the content of those documents, listen to those hearings, et cetera, and determine why they were sealed and what.
And the thing is, guys, right? The thing that maybe a lot of, maybe the thing that's important to remember is that we have to have patience. I know we've been patient and it's been a long case and we've been waiting for things to be unsealed, whatever. Okay. I'm sorry for anyone who doesn't want to hear it, but it is more important for things to be done correctly than quickly. Okay. Things are going to be unsealed and some things may be unsealed, but have some redactions. However, the extent that things will be redacted, I will tell you right now, is going to be way less than it was. Because again, after sentencing, a lot of the considerations that were there that caused something to either be sealed or heavily redacted are not going to be in play anymore, right? So if it's redacted, it's going to be way less than what we've seen. So there's that. Essentially what I'm saying is this. It is way more important for them to go through this and do this correctly and for it to take time and to do it right. So you know what? Everyone could stand to learn how to be a little bit more patient. You know what? And that's what I'm saying. What we want is we want to be able to read the documents. We're going to be able to read the documents. They're going to be unsealed, but we just don't have it right now. That's what it is.
Whether that rationale still is necessary or that rationale still requires the documents to maintain that sealed status. And so before everybody gets out their pen and paper and sends in public records requests, understand those will be denied for sealed records until they are unsealed. And that process is going to take time. And I'm not talking days. I'm probably not talking weeks.
Yeah, of course
For
not.
that to be accomplished. So I hope.
I mean, I expected, in my mind, I would imagine, like, I was thinking it probably would take at least a year to go through all of it. That's what I was thinking. Kane says, you will see in the redacted docs exactly what they have been telling us all along. Who has been telling us? Who are you talking about? The prosecution? I don't know what you mean, Kane.
People understand patients will be required to get through that. As I'm going to
Yeah.
have to review those myself.
Exactly, Heather. Everyone wanting it now. I was thinking of that character from Willy Wonka. Does anyone remember her name? I want it now. That one. I was literally thinking that. I think maybe Heather is also thinking that because we're twin flames.
Those decisions. Now we may be able to speed things up if neither party objects to groupings of documents or specific documents being unsealed. But it's important to review those because those documents may include information that pursuant to Rule 32 are not to be made public, including birth dates, social security.
Birth dates, social security numbers. You guys hear why I just explained this about the redactions? Like I just said, the level of redactions that we've seen up to now, when it's completely different purposes, is things that are redacted, heavily redacted, whatever. Going forward, this is why I'm saying it's as good as unsealed, right? It's as good as unsealed. The least restrictive measure after sentencing, the standard by which something would be redacted, if it's redacted at all, is going to be things like birth dates and social security numbers, or maybe cell phone numbers. That is completely standard everywhere. That is standard everywhere. Everywhere. Literally, the software that we use at the law firm automatically searches for that stuff and tries to redact it. And anything that we make, like say for an expunction, because that has a social security number on it, once we have all that filed and sent in and we've preserved it and whatever, anything that we don't need to keep any, like it gets destroyed. It gets destroyed. Like basically what I'm saying is any redacted birth dates or social security numbers is not the court being shady or whatever. It's just not. That's how it's done everywhere. It's how it should be done. I'm just saying, this is correct. We're gonna get what we want. We're gonna get what we need to know in terms of the documents being unsealed. And if they take that least restrictive measure, and if they're gonna redact anything, it's shit like this. This is normal. This is par for the course for everywhere. It's how it should be done.
Information about minors and victims and information that would be
Thank you, Kane. Veruca assault. Okay.
essentially inappropriate to unseal, including protection of individuals from undue harassment, et cetera. And so that's just going to take time.
I just want to reiterate for anyone who's like, wait a second, what's that? What he's saying is things like phone numbers and social security numbers of individuals, because with that information, people can harass them. Now, people can still, I'm sure people are still harassing people, right? I mean, whatever, they're going to do what they're going to do. But what the court's not going to do is provide things like social security numbers, addresses, and phone numbers, and put that out there on the court record, which makes it far easier for people to harass people, right?
In addition, I'm unlikely to unseal much until after sentencing and after the appeals period has run. Now, I recognize the plea agreement includes a waiver of the right to appeal, but as the parties probably know, the U.S. Supreme Court in Garza versus Idaho has indicated the fact that a defendant waives the right to appeal doesn't mean they don't have the right to appeal. And so it may affect the outcome of that appeal.
Anyone need me to explain that? Because I understand if people hearing that think it means what it doesn't mean. Let me play it again. Does anyone need me to explain that? Because
has indicated the fact that a defendant waives the right to appeal doesn't mean they don't have the right to appeal. And so it may affect the outcome of that appeal, and it may affect the underlying case and the plea agreement. But nonetheless, the right to appeal does not go away because of the waiver. And so I think it's important for that time period to also play itself out to see that it goes the way that I think people intend and expect it to. And so I will be entering an order in the next week or so outlining the process for the review of the sealed records. And counsel will need to maintain a presence in the case in order to review those materials as they are proposed to be unsealed by the court. Because the timeline that I will likely give you will not be, I suspect, extensive as for each group of records. So I might give you 14 days, for example.
The timeline he's going to give them to review these records is not going to be extensive. He's not going to give them 6 months he says, I might give you 14 days, for example. So what we can expect is, like, let's just say it's 14 days, that every 14 days, there's going to be a document dump. And then another 14 days, and then another document dump. And that will continue until all of the documents have been, dumped that hadn't been dumped, essentially.
To provide a response as to a group of, a dozen or a couple dozen records at a time. So just sort of heads up and fair play with respect to that. Any questions by the parties about the ruling today?
Not from the state, Your Honor. Thank you.
No questions from the defense. Thank you.
So Olson, do you have any questions?
And I don't, Your Honor. I wasn't certain if I was included within the parties. I would just say I think that the court's proposed manner of moving forward on the sealed records will likely largely address our interests. So we appreciate the court setting that out in this hearing today.
Yeah. If certain records after review maintain their sealed status, it would be at that point that I would entertain requests for me to consider that more formally and to have a voice in that. But I think until I've gone through that process, it's premature, which is why I don't intend to take up your motion, your more recent filed motion at this time. So,
who was it that said that Bryan Kohberger left this hearing early? He's still there. Didn't y'all say he leaves early? He's still there. He didn't leave. Unless he left and came back, but I didn't see that happen. Twiz seems to be really tired still. Why are you still tired, Twiz? Are you not sleeping? So I know some of you guys have been asking about the Steve interview. Can someone give me a reason why? Tell me why we should watch it. We're not going to watch it now, but we could watch it tomorrow. You guys know how I feel about Steve interviews. I don't watch them. I don't want to watch them. I can't stand them, actually. But if you guys think there's something important in there and you can provide that to me, then I might consider it. but it would have to be for tomorrow. Don't get sassy. He was on the phone. Who are you on the phone with, Twiz? Yeah, Heather's like, I want it now. Who was Twiz talking to? Toses. I don't know what that means. Oh, you've already watched. Oh, you're saying me watch it now. I don't want to watch it. I hate those. I don't like hearing him talk. Like literally the list of things I would rather do than watch him talk is very long and extensive, and think of anything and it would be on that list. Like literally the only thing that would make me watch a Steve Gonsalves interview is if I'm doing it for you guys because I love y'all, and if we're watching it on a live stream together. I do not watch them, and I would not watch it on my own volition. It would have to be forced upon me. Can you say I'm gonna need a little bit more than that. I'm gonna need a reason of why it's wild. What claims is there? Give me one reason specifically. And I forget where did anyone ever say where it was? Did someone answer that? Was it Banfield? I can't stand her either. Fuck. Is it Banfield? I don't want to. That sounds like torture, like masochistic type of stuff. Is it Banfield? If I watch it, it's going to have to be not me watching, like the way it would have to be. Not that I have time to watch things anyway. It would have to be just like on in the background while I'm doing other things that I have to do. And I would be listening to it like not, you know what I mean? Okay, you're saying it's crazy. Anyway, okay, I will see what I can do and if I can tolerate it at all. And maybe we'll watch it together tomorrow if you guys want. We didn't even get to my incredible crazy day today in federal court. I can't wait to tell you guys about it. I really can't. Luckily though, I've got my legal pad here, and I took notes during the entire hearing, and I wrote down so many things. So luckily I don't have to worry about like forgetting anything because I wrote everything down, extensive notes. I can't wait to tell you guys about it, but we'll do that tomorrow. And maybe we'll do the Steve thing depending on it. I'm losing my voice. I don't know if you guys can tell. I'm losing my voice, and Frodo needs to go out. What is going on? Well, first of all, you said you're really tired and you probably need sleep. The state has given them no info. That doesn't surprise me. I expected that. My expectation, given, I don't know, everything, my expectation, and again, having not even watched any of these interviews, my expectation was that the state was fucking them, which seems to be true, apparently. You stayed up for this. Twiz, what are you talking about? Oh my God. Yeah, you need sleep. I think Twiz needs sleep. Frodo needs to go out. I think he probably needs water. Flash, 100%. Flash is making a request. That's a great request. Can I play the hearing again so people can watch it? 100%. I will. I will play it again. Thank you. I'll make a note. Next stream tomorrow, we will start with the 9-minute. We'll start with the crazy hearing with the girl, right? That'll be on the agenda. And we will maybe do Steve. I'll have to see what it is. And if you guys want to watch it again, maybe you guys don't even want to watch it again. But if you guys want to watch it together, I'll consider it. And we'll do the federal court. And then I've got plenty of other stuff too that I have planned too that we will implement. Yeah, Heather, I'm with you on I literally cannot with you, Twiz. Yeah. It is like trying to decipher, I don't even know what right now with what Twiz is saying in the chat. But we love you, Twiz. I love all of you guys. And honestly, I've really got it. Frodo is, I'm not being a good mommy to him right now because he needs things. So, but I love y'all. I will see what I can do with the Steve thing. And should have been in high school with you. I'm wondering if Twiz is sleep typing. But I love you guys. We will reconvene tomorrow. Twiz has a hilarious story. Well, then tomorrow, come on the stream and you can share that story with us. How about that? All right, but that'll be it for now, guys. I love y'all. See you guys soon. But for now, squirrel out.